Yep. All right, good afternoon, everyone. Welcome to what will be our final education offering for the year, which is the extended Twilight Advocacy in the Courtroom. Welcome. We've got about as many people on the webinar as we do here in person, so that's great. Firstly, I'd like to acknowledge and thank our presenters this afternoon. We've got Justice Baumann of the Family Court of Australia. Thank you, Judge. We've got Jeff Perry, Senior Family Consultant of the Family Court as well. Jacoba Brasch of Queen's Counsel, and Rebecca Horsley of Queen's Counsel. Oh no. There we go. Maybe by the end of today. So everyone should have been sent through their materials. You should have had a chance to read over them. As I understand it, Jacoba, you're on this side. You're for the mother. So everyone on this side of the room is Team Mum. Those in the middle can pick which way you want to go. And everyone on this side of the room will be Team Dad. So because it is a longer presentation this afternoon, the guys are going to try and make it as interactive as possible. So you might be called upon to give answers and views on different areas. We will be breaking for refreshments at 5:30 and then coming back to finish off before drinks, which will be closer to 7. So without further ado, we should probably get going. Just in relation to the people on the webinar, if you send your questions in via the application that's available, we will try and get to them at the end if possible. Otherwise, we apologise. There'll be probably lots of questions going on throughout the afternoon. All right, thanks very much, guys. Please welcome our speakers.
Okay, well, welcome everybody. Good turn up. Well, can anyone hear me at the back? That's amazing. If you can't hear me at the back, put your hand up. No. I can hear me. Just get the microphones going well.
Oh, I'm just going.
It's the red button.
All right, I'm going to have to speak louder, and hopefully you can hear me. My name's Michael Baumann. You probably have heard of me, seen me, or avoided me for most of my 20 years on the bench. I'm happy to participate in what I hope will be an interactive learning experience. And there will be opportunities to ask questions, and I hope that in the course of sessions that the council will ask questions of me and or my stream, things that you're wanting to ask. You've seen the program, you've read the material, I've read the material, so as to give it a sort of an authentic touch. I read the material this morning. In the family court, where I've been now for the last 3 years, after 18 years in the Federal Circuit Magistrates Court, and that sort of thing, we get more time to read. So the fact that I don't have to read such big material was a delight. As soon as I saw it, I said, "Look, 5 minutes, work out what this case is about." And like interims in the Federal Circuit Court, as you know, where the majority of work is done, you'll have judges there who have got 15 and 30 matters a day. When I started in June 2000, some of you were probably still at school, we had upwards of 50 matters a day. And I thought I would just read every matter. I did that for a while. And I found that I really had to be a bit more efficient with my time, because they were saying I couldn't sleep in chambers anymore because I was too tired to drive home. So the bottom line is, first thing is, interim matters, anticipate the judge who's appearing before you will not have a lot of time to read the material. Don't anticipate they have read it. They may not have read it as well as you've read it. And you need to be better prepared than the judge, even though the judge is making the decision. And of course, the limitations in interim hearings and the need that there's a truncated hearing is of course reflected in the authorities that you're very familiar with. And that occurs in the preparation. The family court, luckily, we don't do as much interim parenting now. It's done more by Senior Registrar Rice and Senior Registrar Spink. But I still do a fair share of it because I like it. And I've been around so long now, I can do those things I like, which is good. Your persuasion of the judge commences with your preparation of the material. I'm not going to be critical of the material, right? It's meant to be short because this is an occasion about technique rather than content. But when you're preparing your affidavits, I'm sure you've heard in other forums, you really need to think about what it's for. If it is an affidavit for an interim hearing, don't prepare like an affidavit for a trial, because the judge will not have time to read it, and your best points might be lost in the whole stream of things. And you need to focus on the interim relief that you're seeking in terms of the application report. Most judges will have read the material. When we have affidavit evidence, as we do in the family court, the Federal Circuit Court, judges will start thinking about the case. They'll start thinking about the issues. And they will differently, each judge is different, ask you to identify them. Know your judge. That's not an invitation to buy them coffee in the morning. That is an invitation to understand that every judge is different, every advocate is different. We all have our idiosyncrasies. Perhaps unfortunately, there's no other judge in Australia in family law who I've appeared before because I've been appointed before anyone else has been appointed. I don't know what the idiosyncrasies are, but I've probably heard about them. And you're too kind not to tell me what mine are. But I'm sure I've got them, and I'm sure you know what they are. But you need to know that, because like any presentation, which is what a submission in an interim matter is, you need to capture the mind of the person who's going to make the decision. So if you're going down a dry gully, that usually ends up in a dry outcome. The nature of interim hearings is essentially, as I say, truncated. You've got your positions, get there earlier and try and resolve matters that you can. We don't do that because you've got a weak case, you might have, but because that's what the Act encourages parents to do, and litigants, representatives should do the same thing. That is, try to resolve issues, because never forget that when you leave that court, whatever decision you get, the parents are the ones who are going to be parenting. Sometimes they leave an interim decision for a while, maybe for a long, long time. When you're making submissions, as we hear from learned counsel before us today, have an eye to interim until when. You shouldn't be making submissions about an interim hearing unless you're thinking about how long this is. If you're in Sydney, then it might only give you one interim hearing. You could be waiting 3 years. That's disgraceful, not acceptable. You're trying to do more about it. That's not the position in Queensland. But the same question arises: interim until when? This time of year, if you're making interim submissions about things, I'd be expecting you to think about Christmas. Not everyone celebrates Christmas. We have other religious ceremonies in those sorts of occasions with birthdays. So if you're saying, if your answer to your question interim until when is until I get a family reporting, 4 or 5 months' time, think about what other events might come up in that 4 or 5 months' time. Child's got a birthday, I'll know about it because it's on my cheat sheet that I prepare for every matter myself. Not that I don't read chronologies, I just prepare my own cheat sheet. I have for this one. You need to think about that because increasingly we don't have interim after interim after interim. It's an enormous amount of money, it's a cost to parties, and of course, court doesn't have the resources. You would be aware that in the Federal Circuit Court, they've returned to a docket system, which means that you're like have one judge, one case. So from the first day that you appear before that judge, your persuasion is beginning. Don't think they won't remember you. Don't think they'll forget about a poor submission. We all have ways of making notes on files that nobody sees, in our bench books or bits of paper and stuff. I usually remember bad submissions, and I see the person coming in, and I sometimes get ready for it. Bottom line is, more cases in advocacy are lost than won through the inability to be able to properly target for that decision at that time with that judge or adjudicator on the issues that are going to be important on that day. So you don't want to lose persuasion of your submissions by trying to go too far. Don't want to lose your persuasion and your submissions about thinking you've got the best way to describe a legislative pathway. Assume the judge has got a pretty fair idea what it is. I think that what we'll try and demonstrate to you today is that interim decisions can go in different ways. Just like microphones, really. And that really means that you need to be aware of the capacity to have to go down a path you weren't prepared for. One of the things I often see is a person who's so wound up in their case they don't see the other parts of the case. And so when the curveball comes, you might see a couple of those today. They either react very much to type, or they don't say, I didn't get instructions. And that's why I'm getting instructions. You're advocates. If you are an advocate for your own child, you shouldn't be there. But if you are, that's okay. Give yourself 5 minutes. No judge is going to say you should know something about something you never had a chance to think about. They shouldn't. I hope they wouldn't. That's no excuse for you not to say, I need to get instructions on that. The same way that judges who can't quite open their mind, we have those famous words, I'll reserve on that. And you get the time to think, that's how you get. You sometimes, as an advocate, need that time too. Give yourself that time, okay? That's as good as it's going to get, but that's okay. I think rather than spend, that's about the 20 minutes, I wanted to set it up. You've read the material, I've read the material, Counsel had me engaged, had the negotiations out there. Jacoba wouldn't wear like that in my course. You know she's trying. And that's to the extent that we can have a bit of fun, let's have some fun. Because, I mean, our community's been a bit bereft of fun for the last few months, and we've all had to deal with it in different ways. So now it's a bit of a fun time. You need to leave here today with something you've learned. And I like to think every day I learn something. Sometimes people say, I've been doing it so long, I'm only relearning them. So that's the aim of what we're going to try and achieve today. Okay? So we'll open the court. I think we're on time. 4:20, interim hearing commences, and I'll take appearances.
May it please the court, my name is Horsley, Horsley, RA, counsel instructed by COVID and code family lawyers, and I'm here on behalf of the applicant father.
Good, thank you, Ms. Horsley. Yes.
Thank you, Your Honour. Brasch, BRASCH initial J for the respondent mother. She's been in by a team. She's, of course, with little Stewie. I'm going to give
NKIP. And she's not here because,
Your Honour, she has no transport. The funds were behind her eyes, bereft of any money or any
no
support.
transport, eh? Okay, thank you. But she has to take the kid to her, I suppose. Anyway, no transport. We'll get to that. We'll get to that. All right, thank you for that. Well, no, I'm happy to have her here, of course.
Yes, sir.
Of course. So, Ms. Horsley, would you like to, so you're the applicant, Ms. Horsley?
Yes, sure.
So, I've read the material, didn't take it on. Is actually an application, an affidavit, that's what you're relying on, right?
Yes, sure. There's an affidavit of non-filing dispute resolution,
Yeah.
notice of risk document, and initiating application and an affidavit of my client, all filed on 27th of September 2020.
Yes. Well, I mean, if I do very quickly, I mean, the parties don't separate the 25th of, I think there was
September.
September.
Yes, sure. That's
Yeah. All right. Anyway, and you've already had one appearance, haven't you?
Yes, sure.
Someone's made an order for a evidence.
Yes, sure.
And you got that quickly too.
Yes, pleasingly so.
Oh, of course, sorry. It's amazing. Great. Well, and luckily you've got a very senior, I understand, family consultant, Mr. Perry, who one of our best, and he's going to give you some report at the moment. Brasch, your material?
Yes, I read my material, Your Honour. The response filed a little while ago, the affidavit filed at the same time, notice of risk as well. And I do have a couple of housekeeping matters, Your Honour.
Housekeeping, love housekeeping, yes.
The first, is Your Honour happy to?
Yeah.
Thank you. The first of which is there's an annex to the father's affidavit, which frankly, I'm surprised it's there, given it's headed without prejudice, same except to costs.
Yes,
That's Annex 1.
Yeah.
First of all, Your Honour, it should never, that offer should never have been made. The junior solicitor who made it has.
Right, so stop. I don't, are you going to give me the junior lawyer? Are you giving up privilege?
No.
No, because
It's fact.
there's no one junior lawyer didn't do. I wouldn't know. That's a
Well, it doesn't. Thank you, Your Honour. Whether it is attached now and
Yes.
it's privileged. So take you on to section 131 of the
Yeah.
Evidence Act, specifically subsection 1A, it being a communication that's made between persons in dispute or between one or more persons in dispute to a third party. That doesn't matter here, but it's communication without prejudice, same except costs
Right.
as between the parties, and I object to that.
Okay, thank you. Ms. Horsley.
Just for Team Dad for a moment to break out. Who says steer well clear of it, don't be a fool, don't try and get it in? Show of hands. Who says run it hard and try and get it in? Who says I've got no idea what I do?
Who hasn't actually got to Annex 1?
It fell off the other Take the button somewhere. Yeah.
Your Honour, in my submission, section 131, subsection 1 does not apply having regard to the Evidence Act exceptions, particularly set out in subsection 2G. In my submission, there is evidence that has been adduced in this proceeding by the mother, which would be likely to mislead the court unless the court accepts evidence of the communication in the proceedings. The mother in this case raises not insignificant risk issues in respect of Stewie and my client's unsupervised care, including but not limited to family violence allegations contained in her affidavit and allegations of inappropriate touching by my client, Stewie. Your Honour, in circumstances where the letter itself proposes some 10 days after separation in full knowledge of
No. Tell me about why you say it's a matter of law. You say there's no discretion allowed.
Your Honour, I say there's the discretion for the court to accept it in circumstances where it need not be excluded under that particular provision of the Evidence Act. So at first glance, absolutely, I accept that it is a without prejudice communication submitted as an attempt to negotiate a resolution of the dispute. However, I say that there is evidence which would otherwise mislead the court in respect of particularly the mother's case and how it is argued insofar as the risk issue.
Why would you be worried about that?
Your Honour, in my submission, the risk issues in terms of the allegations against the father are such that this court would be inferring that the mother has such concerns so as to now take 2 hours only supervised time arrangement per fortnight as between Stewie and my client.
Yeah.
In circumstances.
Okay, good enough, thanks. Ms. Brasch?
Yes, Your Honour, you have no discretion. Subsection 2 says does not apply if. Now, critically, the if part, there's been a bit of a gloss with the greatest respect to my friend. It says evidence that has been adduced in the proceeding. It's a letter, it's without privilege letter between the parties. It has not been adduced in the proceedings, save that the husband, the husband adds it to his affidavit. That is not
Fair enough,
adduced.
it's out. And let me tell you why it's out. And the guide is that, of course, it's relevant if I knew about it, it would be great stuff. We raise a whole range of issues. But in my view, we need to encourage people to try and resolve matters. If people thought by trying to resolve it, and this is the whole public policy behind the section, that affidavit letters would be annexed willy-nilly, and then I suspect negotiations. And in a jurisdiction like this, negotiations. And by the time I make a decision, you won't be able to get anywhere near the full court to change that rulings. Don't worry, we'll move on. Okay.
I have a second.
A second housekeeping. Very busy housekeeping. Very busy housekeeping.
See my house and home cleans also anyway. Your Honour, if Your Honour would turn up, now I opened this, I'm bringing an oral application to amend my response to the interim orders that are proposed, Your Honour. If Your Honour be so kind to turn up my client's response, paragraph 5 in the interim orders, it's on page 3.
Yeah, you give a notice, Ms. Wood.
Yes, and I texted her yesterday.
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 After hours.
Yeah, okay.
She considers 3:05 after hours. But, all right. Yes, sorry, Your Honour. If Your Honour would turn to paragraph 5. Come to pass with respect to 5A, the family report writer we proposed by the name of Donald Trump, that he's, I think it's common ground, an inveterate liar. He creates division.
I don't need to hear from you.
Well, I've got a bit more.
I don't care.
Well, can I
I'll
go
tell you what I don't care, because when I get to the point about whether the court or anyone else has a family report, we can talk about the usual suspects. And as far as I know, Donald Trump, Joe Biden, Hillary Clinton aren't there, they're out of the jurisdiction. They couldn't give a family report in an effective way. I'll get to the family report if I'm minded to order one. These parties separated 6 weeks ago. We might have to think about, start thinking about the people, whether or not that use of their funds for this forensic purpose at this stage is worthwhile. So before we even get back to who's going to do the family report, you have to convince me we're going to get one. I'll give you a chance to be heard on that later. And no doubt, to the extent you can make criticisms of the integrity of these well-known persons.
I won't be a Hillary Clinton. See,
No.
Hillary president.
Good, thank you. All right. Now, any other housekeeping?
No, thank you.
Thank you. Yes, Ms. Wood.
Your Honour, I understand Mr. Perry is outside.
Yes.
Available to come in and give his
Right.
advice
So
now.
let's go. How Mr. Perry got involved? Someone may have left that.
Your Honour, there was an order made by the registrar on a previous occasion at the first return date of the matter by consent for the engagement of a 11 academic consultant to provide an oral report today. Mr. Perry met with the parties and the child Stewie earlier this morning, and I understand he's in a position now to provide his report orally rather than
Okay, good, thank you. And you have no objection to hearing from Mr. Perry?
Depends what he says.
Good. Now we'll hear from Mr. Perry in a moment. Question 1. The resources of the court are limited. You know, since Hall and Hall, I don't know how many years ago, the court's not bound by the expert evidence of anyone. Judges have to make decisions. However, you know, there's been a raging debate about timing of orders for interventions of this nature. You need to look at what you expect them to do. And before you can do that, understand what the process is. It's limited. Generally, the family consultant who does the interviews for 11F, child inclusive or otherwise, and it's been child inclusive of recent times, it's been by COVID, there's limited opportunity. And then they usually prepare a report. They will have a chance to think about it. In very urgent cases, the family consultant can be prevailed upon to give oral evidence. I might not have ordered a 11F at this early stage, because I think not that hard case really, but nonetheless, it's been ordered by another judicial officer. I respect that order. Mr. Perry's here, and he should give evidence now. His evidence is akin to him giving a written report. Probably quicker him giving evidence because Jeff Perry's a very poor typist. But one of the challenges with taking evidence on an interim basis from a family consultant is the extent to which he or she cross-examines. And the analogy I give you is that if you've got a written report, you wouldn't be cross-examining anyone except Lee. So the mere fact that you have the excitement of seeing a real person in the witness box giving evidence does not necessarily mean that the judicial officer on that day will allow cross-examination to occur, especially for a family consultant who may not be prepared for that. Mr. Perry, so experienced, is probably prepared for anything. Mr. Perry?
Can I just judge? I'm just going to have a character now. I know there's as many people watching on the web, wherever there's the camera, wherever they are, as are here. One of the critical things as an advocate, whether you're a solicitor advocate, barrister advocate, is to know your judge. Because different judges have, it was interesting that His Honour just said, in this scenario, probably wouldn't. But my regional friends who are watching, when they have few and far family report writers that have the resources that we have a level 3, and 11F may be the closest thing that can be done. So it's really critical to maximise your advocacy, even for me to sit up the back of courts and watch, because different judicial officers have different approaches, none of which are implacably right or implacably wrong. It's just how things get done differently, particularly when there are resource issues in the region. So, you know,
I accept that. To me, a lot of it's about timing.
Yeah.
And I start every parenting case with the expectation that these parents want to get out of my court somehow. They want to return to being parents. The more I provide them with a safety net, so they can blame somebody, their lawyer, the judge, the system, unless they take the responsibility which they are required by law and by morality to undertake. And so to keep giving them the answer all the time makes it easy. Parenting is not easy. You don't want to be a parent, don't start. So in my view, the issue that I will often turn my mind to is not about the value of it, because I don't think I've got 11 that hasn't been in some way bad, but the timing of it. And I'm a big believer in what I call differential case management. Choosing the pathway and the techniques for the case, bearing in mind that 90% of cases settle without a final determination. But we have got Mr. Perry here, and he's going to tell us something. Yes, Mr. Perry, could you come in?
Thank you.
Thank you, sir. Assume you've been sworn or affirmed as you prefer. I mean, I always love it when I affirm or swear a witness. More often than you would think, when my court officer says, would you like to be sworn or affirmed? They say, can you tell me the difference? And I say, the questions are going to get hard. Affirm the witness. You know? So, take it that you've been affirmed or sworn, and you saw the family this morning, Mr. Perry. You've helped me and the parties who, and the mum's by Gibby, and Gibby by phone, you can't see it, but she's there, and Dad's here. Tell us about little food.
All right, thank you, Your Honour. Can I just out of roll make 2 quick points? Just adding to what Jacoba said, as a family consultant, I also make sure I know who the judge is. For one reason in particular, that some of our judges, one in particular, like us to meet with the legal representatives prior to giving an oral report, whilst other judges, I think, will take a very different view, in fact, frown. So, again, it's knowing who you're dealing with. The other point I want to make is that I assume that I have seen these people in person. Jacoba's now informed me that the mothers, I would have interviewed the mother by remotely, which also means that I didn't see Stuart. All right, so, and what I'm going to do today is a pretty typical presentation. As Judge Baumann said, Justice Baumann said, it can come in the form of oral report as today or written report. And there's also an opportunity for you to request 2 types of 11Fs. child inclusive conference and a child student conference. It's pretty self-explanatory.
And they're quite different though, Jeff, in terms of time you have allocated.
The time we have allocated and the expectation.
Yeah.
Most of our judges use their discretion in making an order for a child dispute conference if they see that the issues are quite have been narrowed. In fact, this one might have been a candidate subject, but wouldn't have fulfilled today's exercise. All right, so I'll get started. The child subject to these proceedings is Stewie Griffin, born 25th September 2018. Just firstly, some very brief relevant background information to this matter. Parents in this matter separated on a final basis in September 2020 after a relationship of some 6 years. Neither person has other children. Final separation came when the mother left the home in Carindale on 15th September, taking Stewie with her. Since that time, the mother and Stewie have been living with the mother's parents in Gympie. The family has remained in the former family residence. Some 4 days after the mother left, father drove to Gympie and attended the maternal grandparents' property. He spoke to the maternal grandmother and asked to see Stewie. Before long, the police arrived at the property and the father was advised to leave the residence, which he did. The father claims in the following days he telephoned the mother in an attempt to persuade her to return to Brisbane with Stewie. He says he offered to move out of the former family home to allow the mother and Stewie to live there. The father claims the mother refused to discuss the situation. Today I confirmed with the mother that that phone call was made and she agreed that she disagreed with the father's suggestion. On the 22nd of September, the father's legal representative advised the mother that unless Stewie is returned to the father's care, the father intends filing an application seeking a recovery of the Brisbane Registry of the Family Court of Australia. Now, this is probably controversial. I imagine Justice Baumann would sort of not allow me to say this now.
You're on the right, you can't stop you saying something.
On the 25th of September, the father's solicitors received a letter from the mother.
Objection.
Don't worry about that, it's been struck out.
So we move on to risk factors. Studying the family violence. Neither parent reported any past or current protection orders. The mother alleged that the father perpetrated family violence against her throughout their relationship. According to the mother, the family violence was in the form of emotional and physical. He further alleged that on many occasions the abuse took place in front of Stewie. The mother's claims of emotional abuse by the father included allegations that he would harass her, belittle her about her appearance, and make condescending and degrading remarks about her parenting. The mother's claim that the father was physically abusive towards her included allegations that he would throw objects, punch holes in walls, physically restrain her. The father denied the mother's allegation. He told me this morning that he and the mother had what he termed normal arguments, but he rejected the mother's claims regarding me. The father told me that on more than one occasion there were what he termed heated arguments between them, which he said were more the result of sudden changes in the mother's behaviour, which he said had an adverse impact on the parenting of Stewie. The father alleged that during these arguments, the mother would act in a violent manner towards him. In terms of parental mental health, the father claimed that the sudden changes in the mother's behaviour that he says he observed are associated with her history of torment. He claimed that the mother was diagnosed with a bipolar illness when she was a teenager. He told me that prior to the separation, the mother was engaged with the GP to manage her prescribed medication. The father told me that he became particularly concerned about the mother's mental health in the middle of 2019 when he noticed changes in her behaviour. He said that during this period he received a call from Stewie's childcare saying that the mother had not picked him up as scheduled. She did not return home late that night. The father claimed that the following day when he was at work, he received a text message from the mother stating that she was going to end her life. The father called an ambulance and returned home. The mother was subsequently admitted to the Belmont Hospital. The father said he remains very concerned about the believes Stewie is at risk of harm as a result of her unkept behaviour. This morning he highlighted that concern. The father said he believes the mother does not comply with taking prescribed medication. This morning, informed me that he has clear evidence. The father confirmed that she was in fact diagnosed with bipolar illness at the age of 16. She told me she took medication for the condition until she was 25 when she stopped on medical advice. She has recommenced this medication through her GP about 3 years ago after Stewie was born. In terms of drug and or alcohol misuse, I did not identify any risks. In terms of child welfare issues, neither parent reported any past or current involvement from the Child Protection Authorities in relation to the care of Stewie. The father expressed the view that Stewie's welfare is at risk due to the mother's unstable mental health, as said previously. The mother expressed the view that Stewie is at risk of sexual maltreatment when he is within the father's care. She claimed to have seen the father touch Stewie in an appropriate manner. This morning, when I asked the mother to elaborate on this claim, she claims to have that Stewie recently has made a statement to his grandparents that she believes suggests or confirms her concerns in this regard. So what are the issues for this child? His age. He's vulnerable due to his age, particularly in light of the recency of the separation. Neither parent reported that Stewie has any health or developmental issues. The other issue is the nature of his relationship with each parent. It is the father's assertion that he has always had a close and continuous relationship with his son. Mother described the father's role in Stewie's life up until separation as very limited. So I guess the main issue that I identified for Stewie is how does each parent's proposal, how is each parent's proposal likely to affect his relationship? In terms of the party's proposal, the father is seeking interim parenting orders for Stewie to live with him and spend time with the mother each Tuesday and Thursday from 9 a.m. till 5 p.m. and each alternate weekend from 9 a.m. Friday to 5 p.m. Sunday. The mother is proposing that on an interim basis, Stewie live with her and spend time with the father at the Children's Contact Centre. The mother is also seeking an order granting her sole parental responsibility for the major decisions regarding Stewie. Just out of role, that's typically the type of content that you could expect a family consultant to give you. That loosely follows the format of a written memo, deviates a little bit. Some of that I would argue is somewhat repetitive, and I'm always mindful that the judge, the writing judicial officer, can read this for himself. You've got to be careful. However, as Justice Baumann said, I go into these oral reports with the mindset of the judge may not have read it. So I try to give a summary without. No, never. But I also try not to waste the court's time. This is a brief preliminary assessment.
Recommendations, Mr. Baumann.
Yeah. Hurry along. So then the final section that you should expect a family consultant to talk about is future direction. So again, I would normally say that highlight that this was a preliminary assessment, very limited information. But I would say that deciding what future living arrangements are most likely to be in Stewie's best interest, and this is stating the very obvious, will depend on the accuracy and validity of each parent's allegations. The mother says that she decided to relocate with Stewie to Gympie after separating from the father. She says she did this in order to protect her and Stewie from the father. She alleges acted in a coercive and controlled manner towards her during the relationship. She also says she moved to Gympie to get support and assistance from her parents, whom her and Stewie are currently living. The mother's decision to move away from prison has, in my view, caused a disruption in Stewie's relationship with his father. He's 2 years old, and one of the more crucial development tasks for a child of his age is the development of close emotional connections with his caregiver. If what the mother is alleging about the father is accurate, there is a risk of harm to Stewie. The court accepts her claims and safeguards will be put in place, such as her proposal. If the mother's allegations against the father, however, have no basis, then her decision to relocate to Kimberley with Stewie might be viewed as a reflection on her co-parenting. In my opinion, there is insufficient information, at least at this point in time, justifying interfering with Stewie's relationship with his father. I am also, however, of the view that Stewie should remain in his mother's care. This then raises the issue of where Stewie should live. Location. Stays in Gympie, I'd be asking the court to consider the question of whether he can maintain a meaningful relationship with his father. If he returns, then what are the risks for him or the mother? And typically then, the family consultant should then, in terms of future direction, speculate as to the possibility of this matter continuing in court and what they feel might assist the court. So I would say something like, it might assist the court, depending on the capacity of these parents to resolve this matter, for a family report to be prepared, for the mother's medical records to be obtained, and also the records from her admission to Belmont Hospital. Now, I was going to, well, no, I won't say that. I'll say that this morning when I spoke to the mother, however, in her, sure, no, I shouldn't say that, in the mother's affidavit, she appeared with me stopping short of actually accusing the father of sexually abusing Stewie. However, in my interview with the mother this morning, she reinforced that point a number of times. She indicated to me that her belief is now firm. If she does continue to make that assertion, the court might consider appointing an ICO in this matter. Your Honour, that is my opinion.
Thank you, Mr. Perry. Now, we reach a stage where we have two parts. I suspect that either or both of the counsel will want to cross-examine Mr. Perry. They will need my leave to do that. Don't forget, when we look at the family law act in there, to control the proceedings, totally control the judge. Well before Aon, it's in the act. And in a limited situation, there's not always time. Today we've got time, so time's not an issue. So I will hear, and so there's a couple of pathways that we can go. No cross-examination permitted. Sometimes in the past I've asked advocates to tell me anything they want to ask. I'll decide whether I'll allow it to be asked, and I'll ask it. And can I say the other thing I would always do is I'd either get a transcript of the evidence or ask Mr. Perry to get his typing and give me a report, which you need to have it maybe down the track. So I'll come to you first, Ms. Horsley. You got any application about you want to cross-examine Mr. Perry?
Stepping out of role for a moment, taking up on what His Honour said, under the family law rules, cross-examination isn't permitted in interim hearings unless there's exceptional circumstances. To be able to satisfy a justice of the family court that there's exceptional circumstances in a case like this, where you might ordinarily receive it as an 11F report in writing, it would be a very hard push to try and get that report writer present in the courtroom for the purposes of cross-examination. Here today we have obviously Mr. Perry right here. He's given his oral report. There's aspects on my hearing of his oral report of the father's case that he hasn't specifically addressed, particularly concerns in relation to whether the mother is compliant with her medication, and if she's not, what his recommendations are. I would be seeking leave in this circumstance to cross-examine and put that scenario to Mr. Perry. The risk I run in doing that is he firms up his opinion already, saying Stewie needs to remain in the care of his mother, and I open Pandora's box in that respect, and I get answers that I don't expect or answers that I don't want in my client's case, and it really makes it harder for my client to run on an interim basis the orders he seeks. But nonetheless, yes, Your Honour, I do seek that leave.
I think you explained to me, I think, why you like that.
I object, but that will make it a really short evening and you can all go drinking. So I don't object on that basis.
I do. I think it's a very poor, other than exceptional circumstances, we should have a family consultant. And what are exceptional circumstances? I'll tell you the ones where I might have. First off, coming back to, as Jeff said, the nature of the event. In other words, you can't get anything from this little boy, it's only 2. Come here and make a really good observation on it. So all I've really heard from Mr. Perry, with great respect, is what I've read in the affidavit. The only new thing I've heard is that there's been a new allegation, which of course Ms. Brasch will already be trying to find out why it's not in her affidavit, tell me why I don't have an affidavit from the grandmother, telling me about this terrible disclosure that just apparently occurred on the way to the court. The other reason is this, is that often I find a family consultant where I've got an older child and I've got sort of refusal, just won't go back, will not go back home. Orders, had a blue, mum, dad. Sometimes the context of getting a view from the family consultants about the strength of the wishes, even at that early stage, is important because we've hit a crossroad. We're at a crossroad. Am I going to be prepared to continue to press the child to go back to mum or dad, whoever the child should live with, or am I going to give some weight to the child's wishes? And in that respect, I might not take a lot of weight on what the parents say about what the child's wishes are for all the reasons we know. He is my eyes on the child. Family reporters are my eyes on the child. He paints a picture for me. He hasn't painted a picture of the child because he's only 2. We all have 2-year-olds. I've got 8 grandchildren. They're all doing. Bottom line is, that's the parent for the problem in most cases. He hasn't told me anything new. I won't allow cross-examination. Thank you, Mr. Perry.
Can I highlight what Beck said? I mean, in real life, give me a show of hands. If you were there and Jeff had given that, put your hand up and tell me if you would either instructed your counsel or yourself would have cross-examined on that report. Okay, you're all too chicken because you know I'm going to pick on you. Okay, the question then.
But is that because the expectation is you won't get big?
Well, and that's the next question.
Yeah.
Why not? And Deborah Vizio, I can see you there.
She was hiding.
She was, and that's why I picked on her. So don't
Yeah.
hide people, you get picked on.
Good choice.
I mean, people throw some ideas around. I could have, you know, in something like this, a report like that, it's rather meaningless. And Beck, and greatest respect to you, Jeff, but that was the point of the exercise. Couldn't agree more with what Beck said. One of the rules in barrister world, and if you're going to be a solicitor advocate or turning up and I haven't forgotten you yet, is you don't ask a question if you don't know the answer. And occasionally you might ask a question where you don't know the answer, but that's in circumstances it doesn't matter what the answer is. So Beck's entirely right. She could have gone down a path of, you know, there was a classic Jeff left hanging there. It was, where is it? Oh, the mother said something of, you know, sexually appropriate, made a statement to me this morning. Was someone going to be chicken and go, what was it? Because it could have been huge, it could have been innocuous, it could have been no different from what she said in paragraph 20 of her affidavit and the
It could have been the subject of a recent affidavit saying here's the evidence, because courts are courts of evidence.
Well, it could be no more than what she said, you know, it was inappropriate touching of Stewie's private parts and the 11F report has simply missed it at paragraph 20. So scary Doing these things. Think carefully about what you were opening up. And Beck's absolutely right. I might have had a go if I knew the judge, and I wouldn't do it before this one. If I knew the judge, I would probably see if I could, if there was going to be cross-examination, get in about good 2-year-old Mr. Perry. What can you tell us about the attachments to the book? So nothing to do with his report. Now, I would anticipate very quickly someone like Ms. Horsley is going to object, or probably His Honour is going to get it beforehand. But sometimes you might go, I'd be doing a bit of the shore up your own attachment, and rightly or wrongly, we've got to look at the child's perspective, haven't we? Yes, and for whatever the reason.
Mum's in stay-at-home care.
Yeah, mum's in stay-at-home. Dad on his own case is working 5 days a week. Mum says he plays a game. What happens on the father's case if we abruptly take this little? Now, that's not really on the net process.
He expressed his concern. Yeah. That's the problem. Again, going back to when you seek that order, I have no doubt. You know, as you probably know, as a national case manager for family Federal Circuit Court for 15 years. I sat in every registry in Australia, all at once. And I used to see different practices that come out of different registries. Some people just routinely make you like, tick a box. And I'm encouraging people to think in times of limited resources, tick the box only if you need it. Now, when you know what he can do with a 2-year-old, right, unless some person is, say, unrepresented hasn't filed material, and that can sometimes be helpful. You've got 2 people, filed affidavits, given me their case, I heard nothing new from Jeff that didn't know. And secondly, I couldn't think of a question that could be put to him that could be eliciting an answer from that small 1 or 2 hour consultation that was likely to help me. Right? Because you can't possibly make a finding on attachment over the observation of such a short period of time that goes beyond the facts. Common sense. We call it common sense because it's not common. Bottom line is, Jeff has done the best he can, and maybe he could do more down the track. So if I said to everybody in this room, you get 1 intervention and you get 1 family report in every parenting matter, I tell you what, you think really carefully about when you got it and how you used it. I'm getting sick and tired of to go around Australia. It's happened for 20 years. And I've got family report, family report, family report. And you know what it seems to be? It seems to be a manifestation of people not able to make a decision sometimes, or trying to get an expert to give them the answer they want. Fine. Don't forget, family consultants are a different skill set. And I don't know what he was going to say. He might have said, this child, that might have been, the mum might have said, child's got no relationship with the father. Doesn't know him. It's always at work. Sounds like my wife. And he might have said, well, I still did that short snap. I saw this kid run into daddy's arms and give him a big kiss and a hug. Hey, can be pretty powerful, right? So you need to think about the case you're being confronted with, and it is hard because you don't. And the other thing you need to understand is that often I think the practice where we can in Brisbane, I think other states, is that we might try and maintain the same, quite often the same report line. So in the same way as that's the introduction to the family, Jeff being introduced to that family, at a very early stage, they're probably at their worst, till it settles down. He may be required, there might be a little family report. Let's see the application, we'll get to those. And more likely than not, he could be invited if he's done the memorandum. That's still the case, Jeff, where possible.
Where it's possible.
Yeah. Where it's possible. And that's because we follow like the docket system, 1 judge, 1 case, 1 family consultant. You want to say they're biased between your application. Otherwise, kids don't have to keep telling the same story, the same different people. You build on it. You go through the journey. Very powerful.
Can I? Yeah. Thank you. Think carefully about whether you actually need a family report. Yeah. It might be that you've got a littlie and you need to know what's age appropriate. But does one party get 5 nights or 7 nights or fortnight? Jeff, is there any part of your education expertise that tells you it should be 5, 6, or 7?
No. And good family consultant will make that clear. Yeah. I think you're going to a really good point, both of you, in that this whole thing about use of root. I felt ineffective doing that today. I'd be surprised in Brisbane if that would have got 11. This matter.
So can you
information this early? This early. I mean, we might get one.
You might get one down the track, but Justice Bowman's points, I think, is a really important one in terms of what are the indicators for a family report on 11F. Really think of it. It shouldn't be just a splattergun approach. Oh, that's there. It's, we can get that. Why not get it? I think if I had been cross-examined, I mean, I take Jacoba's point. I think that would have been wise.
Can I ask you to come here so that people can see you?
Maybe. I don't know whether you can all hear me. My point is to think about the timing and what you're going to get from what's reasonable to expect from a 11 at this point, or even down the track, a couple of months down the track. Certainly, the age of Stewie, I think, would be important for me to see this boy. Obviously, too young to talk to him and see when they can given the nature of the allegation. But the point is, I mean, I think Jacoba is very wise to say there's nothing she could, there's nothing to wring out of the information. There's nothing, you know, I just felt like I was giving a summary, written paraphrase material. But Jacoba, I think, could have got some ground, made some ground if she goes away from the information and gets me to talk about what we call developmental forecast. Okay, this is a 2-year-old. If this happens, if the court orders this, what's the likely impact?
And just taking that point again, you'll hear me come back to this theme a bit. Case management, right? Good case management doesn't always get good results, but bad case management always gets bad. And if we start from a premise, which I've got to say I have, I'm probably overly optimistic with parents, I guess, I've still got them. If we start from a position that we want these parents to parent, stand up, complain, take responsibility, as most of them can and should do, then what we need to do is provide them tools so they can start to rebuild their relationship, their trust, their respect, and sometimes a good evidence or a good family report helps them. They need time. You need to move from, here's the document. So at the moment, we've just got this oral report. Beck's client's there. He's heard what Jeff said. Jacoba's client's in Gympie. They're probably WhatsApping, whatever they do. They have WhatsApp in Gympie. And so there's nothing. What I'm saying is that you need to give people time to think about it. The benefit of getting a written report that comes out a week or so before the next court event, a lawyer can speak to it, the parties can start discussing it. So that's why this sort of event, I'm not critical of how it's set up, should only, in my view, these are only my views. I can't tell any other judges what they do, except when I sit in the full court. I prefer to do trials, to be honest. But I think this is an event that you might use in limited circumstances quickly. And I think the things that come to my mind is risk. You can't assess risk. He's got no more material than I've got. And he's not, his job is not to determine facts. His job is to apply his skills, his understanding of human nature and seeing so many kids and so many families over, what, 30 years, Jeff? And to look at something there that thinks, that might help the judge make the best decision. What his focus is. I'm sure that's his focus. And he has to just accept that I have to make a decision, but has to stop something. So think about it. There is an opportunity for these. We have the resources in Queensland. The general approach has been to use child inclusive conferencing in the past, I think, Jeff, that's fair to say. Whereas in Sydney, most of the judges wouldn't go for child inclusive conference. They wanted the whole family report. Huge costs.
That's $20,000 a report.
And in my view, a better resource at the right time is what Jeff is doing.
And as you say, Judge, 2 or 3.
2 or 3, but yeah. I think we're going to get a different answer.
And then there's the family report engaged to critique the family report.
Yeah.
Can I ask another question? Sorry.
There are 2 things that I'll add about Jeff's report, because I think that as Jeff has identified and as Honour's identified, there was little that came out of Jeff's report other than what was already in the material. The only thing that came out that was helpful to my case was that the father is on record now via the consultant as denying the allegations that the mother levels in her response material. No affidavit in reply from him dealing with the allegations of inappropriate touching or the allegations insofar as family violence are concerned. I'd be doing something from the bar table, which tends to happen at interim hearings, unfortunately. Your Honour, there's no evidence before you about it, but I'm instructed that my client denies the allegations that are raised in paragraphs blah, blah, strenuously, and it's simply a matter of the late time frames in terms of the filing of the mother's material. Otherwise, we would have an affidavit in reply about those matters for you today. So that helps. But also picking up on what His Honour said in relation to the timing and the use of your resources that you have available to you, particularly if it is a family report that you're waiting for, whether it's court appointed or whether it's a privately funded one. Jeff picked up on 2 things that would help this family more and help the court in the determination. Getting some more medical records about what has been happening for mum. Do that before the family report interviews, get that information either by agreement to the consultant or have an order which gives leave to the consultant to inspect that material. But also keep in mind that if that material is thousands of pages long, you're going to assist a time-poor, overworked public servant in doing their job.
Servant of the public.
Servant of the public, by going along, highlighting or tabbing the relevant documents and trying to get agreement on an abridged bundle to provide to that expert. Make their job easier so that your client's case in relation to risk in mum's household is assisted. Otherwise, it's lost potentially in the volume.
It might be just worth noting too that there's no expectation that family consultants will have read subpoena material. That's one of the things I find when I'm often judging side. You know, there'll be an attempt to say, well, if you were made aware of this, then most judges.
And that identifies the real need to know what the service offered is. It is not a limited issues family report. It's not a short and dirty family report. It's not any of that. It's someone with different skills looking at the family and trying to work out why they're here. And it's something he can say to help me as a decision maker, work that decision. And when you and you need to understand that. Queensland, generally, most of our family consultants have been social. In New South Wales, most of them are psychologists. If you get Sydney Council who want to argue for the first half hour about who's better, I can tell them to shut up. Because it's not their technical skills that I'm not asking to do psychometric testing. You're social with that. Yeah. I want people who experience with families and kids and have a look at them, bring my eyes on them, and give me some information that I can use. Because I tell you what, the affidavit's sitting in there a hell of a lot to work with. So I think be careful about that. Having said that, I know that probably some judges who go through a certain methodology. I encourage judges that came to the Federal Circuit Court after the initial hate, of which I was one, to try and understand each case needs to be thought about differently. If the judge won't do it, you try and make them think about it. This is what we need. This is how we'll help you. It's too early. How about we look at some alternative dispute resolution? How about we narrow the issues? Whatever. We'll get to that in the course of it. Of course.
If I was cross-examining a family consultant,
Social worker. Get it off your chest, man. Get it off your chest. You want to do this for 30 years.
You sit in the there and off you go.
Look for what Justice Baumann said. Is this about this kid? Is this about Stewie, a 2-year-old boy named Stewie, in this family, in this country? Or is this family consultant talking about children in general? And if I was the barrister, I'd really go up. And the third point is, are they going outside their area of knowledge? So 3 big on bias. Are they being, are they being impartial? Where are they going? How are they arrived at this decision? Unfortunately, and this is probably advice we'd like not to get out, but that's what most family consultants worry about. Being asked about, show me the pathway you got to that decision. How did you get there on this thing? I mean, a family consultant, if I had made, and I was going, say, role play, make some bold recommendations, no time, supervised time only. Well, I think, counsel could really go at that. So.
And even if you're not given leave to cross-examine, you can make those submissions.
Absolutely.
So don't think everything is lost if you're not allowed to cross-examine. Your Honour, you cannot see from Mr. Perry jumping from merely reciting the affidavit material to his recommendation. We cannot see the chain of reasoning that leads to no contact and the father should be sent to Siberia. There is nothing, so you've still got the ability to make submissions about the length of interim hearings or the lack thereof. Can I invite you not to turn to the last page first? in either an 11F or a family report. Because if you do, you lose your own forensic advantage. If you're reading page 1, 2, 3, get to recommendations or the suggestions for the way forward as an 11F is, and if it kind of makes sense, you go, okay, there's probably, chance it's methodologically sound. If you're reading, you get, where the hell did that come from? There's a big hint to you that there's something missing.
And it does happen. And I always think, if I was questioning this person, I'd really centre on.
And also, Jeff, I think it's difficult for consultants. I think they feel a bit under pressure at times to make a recommendation.
Yeah.
And I think they shouldn't feel that pressure.
Yeah.
Now, I know people want it.
Yeah.
I know some judges who crave it.
Yes.
And I'd start with the sort of scenario, well, why wouldn't I do what Mr. Perry said? He's a very reasonable fellow for a long time. And so if you go down that track, you're immediately going down the wrong track. You're blurring the roles. He's an expert on a field. And sometimes the most powerful family reports I've seen over my 20 years as a judicial officer have been ones by experienced family consultant or expert witness who says, this is really tough, this is finely balanced, this is really close. Here are the advantages, here are the disadvantages. And I'm not paid enough money to make a choice in any way, you'll make it, that's your job. Right? So sometimes, and of course you've got to remember, in a trial situation, not like here, by the time you get to the end of the trial, sometimes the evidence ain't quite as good as it was at the start of the trial, or the affidavits, or when he saw them maybe 12 months, 6 months, or even 3 years ago. And so you've got to keep a little bit in reserve, and as a judge, I think it's helpful. And the thing I say to Jeff, and I used to say this when I used to go and talk to the family consultants around Australia in my other role, if you're worried about how good your family reports are, think about how many reports you make and how many times you've been asked to be cross-examined. Right? I can tell you now, the cross-examination of family consultants or experts in this country is tough work. We find it really hard to get people to do it because who really wants to be cross-examined by chats?
Jeff loves it.
Right? And who wants to do that? But they do it, it's tough work, it's highly valuable workers. And I would think, Jeff, probably less than 10% of the family reports you've read over years, have you ever been required to justify? So it tells you that usually they get it right, or it's been part of the catalyst to the parents reframing their positions or thinking about what they should do for their child. So the value is not for the trial necessarily, it's quite often to help these parties get on their own track.
Judge, it's just a snapshot, so it cannot capture the dynamics of families. Families are a living organism, And I think that's where some lawyers keep wanting to chase a solution, chase an answer.
But there is one single right answer that fits.
I think that's the greatest friction between law and social science.
Yeah. All right, Jeff, I look forward to you getting a law degree and starting up a new career.
Before we go,
I'll be able to give my
question for both of you and Beck. Now, this is truly outside your expertise, Jeff, but I'm going to ask it anyway. There's some suggest my client's got bipolar. There could be a tendency to go, oh, we've got to get a psych assessment. Think about that as well. And think about, I've asked you to think about it, if your dispute actually warrants a family report. Equally, getting a label on someone in a mental health sense, does it matter? My first ever cross-examination of Frank Varghese, thank goodness I was for the children so you can get away with it. Oh, Dr. Varghese, you've diagnosed the mother with histrionic personality disorder. And I said, well, in terms of the capacity to parent, what does that mean? Thinking, oh, this is big exciting. He went, not much really, kids love a bit of drama. I mean, literally, and Frank enjoys telling that against me while I get first at CPDs. But think about it. Think about, if there's a diagnosis here of bipolar, does that automatically mean we need a psych assessment? Or does it mean, as Jeff suggested and Beck's already picked up on, medical records? Medical records. Because if it turns out she does in fact see her GP and has for years, every, I think she says 4 or 5 weeks or whatever, and if littered through all of her GP's records, it's compliant with meds. Yeah, she fell off, you know, she had a difficulty last year, but she says, you know, she tried to, thought about taking her own life. But she explains that as a measure of how miserable I was. But think, please, and insofar as anyone here wants to make some comment about, do you need a psych assessment? What's the label going to mean?
I can only echo what you're saying. The question for family consultants is how does that link? What's the link? What does this diagnosis mean for parenting? So always bring it back to parenting capacity. In and of itself, mental health diagnosis is not necessarily exclude a parent from being able to care for a child. It can, but it needs a lot more analysis than just a simple, you know, analogy or connection between a certain diagnosis and a certain impact on parenting.
And look, Jeff, sadly, in my experience, psychiatric reports are ordered far too often because of that very reason.
Yeah.
And now, thankfully, legal aid will only give you aid for psychiatric assessment if there's exceptional circumstances, and properly so.
Yes.
The test for a psychiatric examination independently is not the husband saying, I think my wife's mad. But sometimes it's no more than that. And so I must say, I don't have a view that just because people are having treating psychiatrists or psychologists, that their evidence should be discounted because of their therapeutic. Now, sometimes it's a bit challenging when you get it in the witness box, but often they'll kick and scream about giving evidence because of the therapeutic relationship. But there needs to be a foundation set, and the foundation will generally be some past psychiatric attention, hospitalisation, and a concern about whether the person has insight and or her behaviour, his behaviour running through the matter has been has caused a deviation in behaviour that might have been modified with medication therapy. And you've got to go through all those hoops before you convince me to get a psychiatric. But of course, as you know, Jeff, a lot of psychologists and social workers who are trying to work it out might say it's a matter of trying to, I just don't know what's going on, you should get a psychiatric. And when you see that, the judge shouldn't just think, oh, that's a good idea. Because I can tell you again, I know it's just anecdotal, but I would be surprised I've had more than 5% of psychiatric reports in 20 years that have ever told me something that wasn't otherwise obvious. Okay? Enormous expense to legal aid. Sydney, they're charging 15 grand to get a psych report. How many family reports do we have for that? So again, people have different views because they're looking for an answer, looking for something to hang their hat on, right? So you need to do the work beforehand. Get the psychiatric background. If there's a GP who's been getting mental health plans, get the GP's documentation. Find out why the mental health plan was prescribed. What was the basis upon which the client, the patient, said, I need help? These are things that solicitors and those preparing cases for counsel. We'll get back to this, and we'll get soon after drinks in about 10 minutes. We'll go to drinks. Counsel is only as good as what they got before them. So the solicitors in the room here, don't expect these people, they're magicians, to do the best they can, but they can only do it on the evidence they've given. Your job, we haven't a lot of time in this case, is to get the best evidence, right? Best evidence.
Picking up on that evidence issue as well, Jeff started to talk about mum's offer for week about time, which was excluded and wasn't accepted into the evidence by the court as part of the housekeeping objections that Jacoba had raised. That takes away a lot of dad's defence to mum's allegations. The fact that mum made an offer of week about time on dad's side of the fence is very much inconsistent with the suggestion that he's any risk to this child. He's flabbergasted when he gets her material, never hearing of these allegations before, anything like that. The fact that he's not able to have that in evidence or give that to the judge to say, look, you've got to second guess what she's telling you because she wouldn't have offered me this if she truly held these concerns. That is what that section of the Evidence Act and the exemption is related to, and there are some circumstances where a judge will allow it. If, though, Jeff, you were able to see that in your material, what's your role in that respect? Do you then get to question her evidence, or do you just flag it?
I would flag it, but I might. might make a difference drawing from it. I would think about that, though, whether I'm going outside, yeah. But I
Aren't
might,
you then taking something into account that's not in evidence before the court?
But that's what I'm saying. So if it's allowed,
if I
and
can.
it's allowed,
Yep. And I would have then maybe expect a question, what do you make? And I might
Well, not
say,
from me, because it's not in evidence.
no, that's right. But I
we'll
might,
ask the mother about that.
Yeah.
In terms of, yeah.
and I've had it put to me, what do you make of the timing of it? And there's no history, there's no track record of any concerns reported by the mother, Now, after a week or so of leaving the home, she's made this proposal that seems to contradict her allegations. And I think that leads to another point I'd like to make, and I think Justice Baumann made earlier. I think a lot of your job is to try and appraise what is these parents' attitude to co-parenting? Is it about, have they really adjusted to post-separation parenting? Or is this a transition? Are they still in that transitional mode? And one of the things I would make about one of the observations I make is that it's damn hard to make anything of it because
It's too early.
it's too early.
It's too early. I mean, the bottom line is that when I was chairman of legal aid back in the 90s, we had a policy then, I think still applies to people legal aid here. You couldn't get aid, it's exceptional circumstances within 6 months of separation. There's a good reason for that. People are going through grief when separation occurs for a whole range of reasons. And they're not always able to clearly think. I gave the analogy, I think, back a month ago, that when the federal magistrates court then was allowed for the first time, that'll be my booking time or even later, for the first time you could file a divorce electronically. We had a flood of people filing divorces at 2 o'clock in the morning on a Saturday. And the only reason they didn't get onto the portal was because they were so drunk they couldn't go through and put the card in and get to pay for the fee. Look, someone said once before, in criminal law, those who used to practice in criminal law, if I came to school, criminal law, you got sometimes people a bit shady, a bit bad, who are trying to look really good to the judge. What we see in family law is, generally speaking, good people who just look bad to the judge. And we need to have that context. So again, everything we're saying is about context. And that's why, I give you my own personal thing. I always do a chronology for every trial I do, my own chronology. I want to see where things fit into that context. And this is the context at the moment concerns me, is we're very early in this post-separation. 2-year-olds are absolutely infectious. And of course, pain, we need to understand that. So we should be thinking these people need all the wins and all the bells and whistles. We're going to get into a trial. They're a long way from there. More likely than not, this material, never going to get there. Never going to get there. Yes.
Do you think in that case then parents should be, it should be a mandatory like coaching or training all parenting matters?
Well, before they conceive, absolutely. On the basis that wasn't what the question was, I suspect. Well, this is a case where they so urgent they got an exemption under 60I. The 60I is there for a purpose. To have these parties try to think about it in terms of their child, not in terms of their own. And you're a mediator, I think, and you would see these people. You give the certificates, I suspect.
So, given the 90% or so that you were talking about earlier, that go through this process maybe for a year or two and settle out of court anyhow, is what can we do to try to?
Okay. We're going to finish this session at 7 o'clock. I don't have time for that. But it's a quandary that we're all being struggling with. Right? Remember this: kids get the parents they get, not the parents they want sometimes, the parents they need. And you're not taking them home. So you're going to work with these people, try and get them. Last I want to say that we've got about 5 minutes left before we're starting to have drinks, and then we'll come back and hear submissions. I want to say something before we go to drinks. Is there anything else you wanted to say at this point? Or-
What can, yes, there is,
Yeah.
of course there is, there always maybe my third Debbie Downer for the afternoon. Think about the letters you write. We want parents, if we want parents to co-parent or parallel parent or something, if we're going to take parents to task on the other side because of some of the things they've said or done, think about the letters you write and what you're modelling to your client and to the other side. I get a bit sick and tired of the 20 letters that have been received by 9 a.m, all threatening indemnity costs and your client this and your client that. What message? I mean, if we're sending a message that that it's adversarial, let me chuck another incendiary device in. I mean, I like when Judge Lapthorne went through a phase. If I see, you know, Dr. Brasch, would you please put out to the bar that if indemnity costs, I consider, unless there's a proper basis, I consider that to be a form of family violence in itself. But think about, are you, as a lawyer, you catch more flies with honey. Think about the threatening letters. You know?
We don't write it unless you're happy for the judge to read it. When I see some of them, I see solicitors just putting their head down like this. They're self-serving, they're intimidatory. On litigants in person, they're just often harassing and they're not helpful. So why would you do something not helpful? Anything else you want to throw in?
Thank you.
Anything else you want to throw in?
Non-six and indemnity costs.
Yeah.
See, that's the third bit of housing language leaving up on that.
Well, when you got a firm like pandemic lawyers,
It'll come as no surprise that I won't be pursuing that, Your Honour.
Yeah, no, don't worry about that. Let me just say we're going to have a break. I'm going to throw a curve and I have told one. Obviously, we all know, thankfully, the judge is not bound by the phone. I court you and you tell you all court decisions about that. And the reason for that is pretty clear, because the test is what's in the best for the child. What the law does require, however, is if there is an alternative proposal, then parties have to be given an opportunity to be heard of. You just can't lob it on them, say, no one addressing on this issue, but I think this is the answer. That's not procedurally fair, and it's not actually helpful because you don't get the feedback. So as we're going to adjourn now, because I don't know why they're adjourned, but they're going to adjourn for 20 minutes so everyone can be refreshed. I'm going to require counsel to consider an alternative proposal. I want you to get some instructions. I know that the mother's in Gippy, so she can give you some instructions.
She has WhatsApp.
WhatsApp. Fantastic. And there's all the organized here. I've read the material. I've only got a preliminary review, of course. So I haven't formed the view. I haven't heard counsel's submissions yet. I hate to be prejudging the matter. Although, when you read material, you start thinking about it. The concerns for me about this little boy is, A, why isn't he his own home? B, in August this year, he was put in daycare 3 days a week because I think the mother said the parents agreed he needs socialisation. So he started to develop something there. C, the father said that he's got other alternative accommodation he could go to. D, if there's both that sort of area, then the flexibility of time increases. We move through the stage of this matter. From stable advice, this little boy, this is the only home he's known. This is the place where his toys are, the place where his cot is. He's now in a bed, too. This is where he's hit his head. These are the things that are important when you're two, I imagine. I can't remember. And so, before people, learned counsel start telling me about statute of Hartford number 10 and coercive orders, reread Justice Bauman's decision in the full court in Miles and Morgan about quick unilateral relocations. Not really relocation, 2 hours up the road, but this has to be what's in the best interest of the child, and I want to hear from both parties, apart from your own position. I want to hear why it wouldn't be the child's best interest. And the third alternative, this child return to the home on an interim basis, that the mother returns the home with him. He remains in the home. I appreciate that no evidence of that. He's going to pay the mortgage, he's putting on a mortgage. They might have to sell the house eventually. Grandma on the Gold Coast, Thelma, I think her name is. I know what happened to Louise, but anyway, Thelma, she can come up to the Gold Coast and visit. And grandpa and grandma from Gibby come down and visit. And this little bloke might start getting into some sort of stability. But we worry about what happens when families break down and people cope with it. Traumatic. I'm lucky I've never had to deal with it personally. Married the first girlfriend, looked best decision I ever made. But as dads and these got parents, at least one of them knew it was probably coming. Usually one of them is better prepared than the other one. The children are generally never prepared. We know that because, again, Jeff, in your experience, how many reports do we get from kids saying, even when they've been fighting and carrying on, I just want mum and dad to be back together. What I want what I knew. I want, and every time I read that, I say, I can't give that to your kid, I'm sorry, can't give it to you. Your parents are going off and another tangent. At this stage, by the time I get it, they're long way.
Can I just say one thing? What you're doing there is trying to shape an order around doing two things. One, reducing alleged risk, but also trying to return the child. You're shaping the orders around the child's.
There's heaps of other flaws there, mate, and you're absolutely right. And what I'm asking these people to see if they can move from their entrenched position to something which I think is at least arguably in the best interest of the child. That's a test. Okay, we're going to have to get with one last question, one last statement, which I tell again to myself, and it deals with letters. And those of you who know my career know that I started my professional life as a solicitor on the Gold Coast. And I started my practice when I was 23 at Courtroom. I started there because it was the best service in the Gold Coast. Those days I had more hair than I have now. And I recall having a matter, I can still remember the matter, it's called Blaisley matrimony. I only had about 4 files. And I remember writing a letter to a solicitor in Penguin, Tasmania. I've never forgotten it. There was a place called Penguin, never been there, but apparently there's more than penguins there.
I've been there.
Yeah.
And there's the penguin butcher.
Yeah. Anyway, I remember I had this matter, and I had this solicitor in northern Tasmania called Greg Richardson. I think his son might be a lawyer around now. And I had a lot of time, because I was typing my own letters, to write this letter about Blaisley matrimony. It was a beautiful letter. I told him all the things I was going to do. I quoted the law. I had a lot of time. I was 23. I was pretty hot. I can tell you. Anyway, I sent this letter up. A 3-page, beautiful letter. There's no property. What Penguin houses in those days were worth about 15 grand. I sent this letter off to Richard's sister in northern Tasmania. And I was so anxious to get a response. It is before we had email, really. So anxious to get a response. He's going every morning to the post office to Courtroom to get my mail. What else do you do when you've got no work? I finally get a letter from Greg Richardson, solicitor, Launceston. Fantastic. Here I go. Here I carry on. I go back to my office. I get my cup of tea. I sit down. I move my couple of files and put out the letter. Open it up. Dear Michael P. Baumann, solicitor, Tea Tree Avenue, Courtroom. That's not here anymore. Read Blaisley matrimony. Go for it. And what do you do with that? All you can do is ring up Greg Richardson's sister in northern Tasmania and say, Mr. Richardson, don't you write such a stupid letter. How long have you been in practice? Not very long. Right? You shouldn't write those sort of letters. Blah, blah, blah. If you want to talk about resolve this matter, talk about, don't write those stupid letters, Mr. Richardson. I'm sorry, I I've told that story over the years. It's true. It taught me something. Greg Richardson was a very angry person. But more importantly, respect the profession, respect the other person. You're in an area of jurisprudence and jurisdiction where they're going to have as many hard clients as you're going to have. And writing letters, getting off on the wrong foot, and getting a reputation as sharp, but not for the right reasons, or ethically a little bit discoloured, is not something you want. Because you're going to be working with these people in this pot, in this hub, as we now call it, for a lot of your career. And there's hardly a client I've ever seen in all the years of practice that I had that was worth it, voluntarily or otherwise, to compromise your ethics or your relationship with good practitioners with whom you work. So, we'll have a drink. Never take the vision. Okay. Come back, bring your food, bring your drinks. If you're famished, you'll have more drinks later. Cold and ready. Okay. We're now going to move into the section where Ms. Horsley and Ms. Brasch will make some submissions. A bit like, nothing like Supreme Court. They'll be given 10 minutes each. I don't have a bell to stop them, but they'll try and do that. And of course, as you know what their proposal, I expect to hear submissions both with respect to the merits of the interim parenting and something about the case management pathway, and then about the alternative proposal, which they will take some instructions on. We'll let them make their submissions, and then we might have discussions along the way. And I'm sure that it's not what I want you to do. I want you, when you're sitting there, in all these other places where you're sitting, to now go into the mood of saying they are making the submissions to you, and I'm going to have to make a decision. Right? Inevitably, it's much, much harder to make a decision about two coherent, well-argued positions than it is to make one articulate, well-argued position. And anyone who thinks it's easy has never done it. So you know what the facts are. The case is a lot harder than this. It is a little example. And I'm not going to have a show of hands about who would have said what, because that's embarrassing. In my experience with crowds, people putting hands up, it's most people are like ground scouts, I'll follow the crowd somewhere. I don't want you to do that, it's not about embarrassing, but I want you to think about these submissions and think about what I might ask if I was a judge. Well, you may be a judge. I don't know if I could. Some people still don't think I could do it.
I'm on the road.
So you do the same thing. I want you to think about it. I want you to think about it, right? I won't be embarrassing anyone and getting you to say who did this and did that. You don't need to do that. not here for popular vote. I'll be a little judgment. It's not going to be, Oscar's not here, it'll be very short and sharp. I'd rather spend more time on listening to submissions and you thinking about what you would do if you were. Okay? Yes, Ms. Awesome.
Your Honour, thank you for that opportunity to take instructions in relation to the alternate proposal that the court's given consideration to. In that respect, can I indicate my client's instructions are these. As you will have already seen in his affidavit, on the 20th of September, he offered the mother that very opportunity to return to the family home with Stewie. It was, given the evidence of Mr. Perry earlier, a common ground that the mother did not agree to that proposal. It's understood that she continues not to agree to that proposal, albeit I won't go into her reasons why. The father contends this: if Your Honour is inclined towards that proposal, that the mother would return to live in the home and that Stewie would return with her. There needs to also be injunctions in relation to her complying with the medical treatment as prescribed by her treating GP or psychiatrist, including taking medication as prescribed in order to alleviate the risks that he says are present currently in the mother's household. And additionally, there would need to be some clarity in relation to issues such as the financial arrangements for the parties in relation to the mortgage. Now, Your Honour doesn't have the benefit of material from either of the parties in relation to their financial circumstances, but it is noted that the mother is reliant on government benefits, child support and the like, and the father is currently employed on a full-time basis as a safety inspector. So it's clear that there is capacity in respect of the husband currently meeting those arrangements, but ultimately if he's required to obtain alternate accommodation, it's his case that he would need to incur additional expenses in that respect.
But it says in his affidavit he'd be able to move into the free.
Your Honour, it does, and it was proposed on a short-term basis. At this stage, what's being considered is a more long-term arrangement, appreciating these interim arrangements will be in place for some time. It's expected. Well, Your Honour, in circumstances where the parties propose to engage with their family report, that would be at least some months away, and ultimately the availability. Well, Your Honour, I can address Your Honour in that respect later, unless you require submissions now, but those were the preliminary matters that I was instructed to raise if Your Honour is minded towards that alternate proposal. I nevertheless have instructions in circumstances where it's understood that the mother does not agree to returning to the family home to press my client's primary application nonetheless for Stewie to be returned to Carindale so as to re-engage with the Mother Duck daycare facility where he's been attending 3 days a week since August of 2020 until the mother's unilateral removal from that arrangement. It assures his return to the family home. And Your Honour, in terms of alleviating any risks which are identified in the mother's material, appreciating that Your Honour didn't allow. Your Honour, the mother raises issues in respect of family violence specifically towards herself by the father. The father denies those allegations, but I accept it's a disputed matter that the court can't make any findings on an interim basis. And additionally makes some allegations in relation to inappropriate touching of Stewie.
Tell me about the family violence.
Your Honour, in relation to the family violence, my submission is this: he denies it. Secondly, the allegations are so vague as to be unhelpful. The only allegation insofar as Stewie is concerned is that he was exposed to arguments as between the parties. That will not be occurring, given that the parties will not be residing in the family residence together. And thirdly, the only allegation insofar as harm to Stewie directly for the father's behaviour is, even on the mother's case, inadvertent, in that there was a bouncing off the snoo rocker and actually hitting the child with a telephone that was thrown in anger. So even taking the mother's evidence at its highest, Your Honour wouldn't be satisfied that there was any risk in the father's household to Stewie as a result of those matters that are raised in her affidavit material at this preliminary stage.
What about, in your affidavit, I think you indicated what hours you find.
Yes, Your Honour. He works from 9 AM to 4 PM, Monday to Friday. He also indicates in his affidavit that his hours are somewhat flexible in that he anticipates he would be able to speak with his employer and make arrangements. He also refers to the availability of his mother, who lives at the Gold Coast, to assist in Stewie's care if necessary.
Well, don't rely on Redmar. He wants residents.
He does, Your Honour.
On a temporary basis. So what's going to happen on the days when he's not in Mother Duck?
Your Honour.
He goes Monday,
Wednesday and Thursday, yes, Your Honour, and Mother Duck has confirmed on his evidence that Stewie has a place there, which is great. The father's orders as sought, Your Honour, proposed that the mother would be spending time with Stewie from 9 AM until 5 PM on a Tuesday and a Thursday, Obviously, if it were the case that there were 2 particular days each week that the mother was spending time with Stewie, ultimately what could occur on the father's instructions is that there would be a change of the 3rd day of daycare from the Thursday to the Friday. Your Honour, there's no evidence before the court in that respect. No.
And how's he going to get the child to where for the days that he's working 9 to 4?
Yes.
And mum's going to have the whole day, and he's going to have wherever they meet. The kid's going to have 2 hours travel one way, 4 hours out of the day. Why would that be good?
Your Honour, in circumstances where the father and Stewie would be based in Brisbane, it's the father's case that changeover and time with Stewie for those daytime visits should occur in Brisbane rather than require.
So where are you proposing mother take the 2-year-old for the day?
Your Honour, in circumstances where the father wouldn't be within the residence during those hours, it would certainly be available.
Shared nest syndrome.
Without the requirement that parties will continue to share the residence, Your Honour, it's certainly an option.
So lock up the filing cabinet, we don't want to see documents, and we'll have them moving in and out of the house.
Your Honour, in my submission, it's a child focused proposal on his part in circumstances where it is Stewie's environment, and but for days that he's in daycare, he would ordinarily be in the household. It's not, Your Honour, but that's my submission so far as the.
Right.
Yes, Your Honour.
Just. Well, what I want to know is how this actually going to work. See, the common material about 4, 9, 4, 50. I hear what he says about flexibility. But it's right is that he actually hasn't had to do it at all, other than the 5 days when we did go.
Well, Your Honour, in my submission, that's not quite the case. His affidavit specifically says in paragraph 13 that he has always been involved in Stewie's
No, this is the question.
Gets him drunk.
That's what I asked you. It's all thing you well know. What I've asked you is, the evidence seems clear that this child has been in the care of the mother who's unemployed during the week. Your client has had time before and after. What I'm saying is, apart from the 5 days she was in Belmont, is there any other evidence you can point to that he has had the primary care of this outside that opportunity?
Outside of his work hours, yes, Your Honour, but it's common ground as between the parties that he has worked full time and the mother's been a stay-at-home.
All right, so let me start, because again, sadly, and your case is the same as Ms. Brasch, you should get the same sort of question. Why do people bring applications about 2-year-olds and don't tell me things about their routine? Are they still sleeping? Where do they get up? Do they have an afternoon sleep? Where do they go to bed? I think you know about these things, Ms. Horsley. You've got a 2-year-old. And so I want to know, because the last time I looked, you can't bond with the child sleeping. So what I wanted to know is, if Dad gets home from work at 4:30, when does this little 2-year-old go to sleep?
Your
No
Honour,
evidence is there of that.
Your Honour, there's certainly evidence in the mother's affidavit that points to Stewie's waking time being consistently 7 AM. There's no details in respect of his bedtime. I accept that, Your Honour.
And should I accept that there's a healthy, normal little boy, no other major problem?
Yes, Your Honour, neither parent raises any concerns, and I'm instructed that there are no such concerns.
Now tell me about the other case management of it, because your time is nearly up.
Your Honour, insofar as the case management is concerned, I note that the mother's orders sought, in fact, outline her panel of experts, alleged experts, in that respect. And she also says that she would be the person to nominate from her own panel. I'm sure that that is a typographical error. Your Honour, my client, Brasch, schedule that my instructing solicitors made some inquiries today. It seems clear that Mr. Biden in particular is likely to be busy for around the next 4 years. Told that Mr. Trump is in fact announcing his retirement late this week.
Oh, don't jinx it, don't jinx it.
From my client's perspective, Your Honour, Ms. Clinton, whilst no doubt appropriately qualified, lacks the experience that Mr. Perry has, and my client's preference would be that Mr. Perry would be engaged as a family report.
And we need a family report now. Why?
Your Honour, in my submission, it will allow for the ascertainment of those medical records, the queries that Mr. Perry identified in his oral report today. It will also allow for the parties to, presuming that orders are made in the meantime, settle into a routine with Stewie, allow for observations to be undertaken by Mr. Perry, if he is the appointed report writer, of the interaction as between Stewie and his father in particular, noting that that wasn't able to occur today. Allows for a more fulsome report to be prepared and potentially assist the parties towards a negotiated settlement at the end of the day, Your Honour.
Yes, anything else?
Your Honour, can I just say, in respect of the orders sought by my client in particular, I wouldn't be pressing the recovery order application.
Ms. Horsley. Why would you think it appropriate for me to assume, having already seeking from me an order that the mother return the child to the father, that I would feel so confident that I would force the police, usually the state police, the federal police have jurisdiction, state police, to go to the mother's home, drag this 2-year-old over arms? Why would I make a recovery order? Can you give me a good reason?
Your Honour, it's the concern of the father that the mother may not be compliant with the orders. That was
Well, where's the evidence he hasn't been compliant? There's never been any orders. Why
Yes,
should I do?
I accept that, Your Honour, and it's in those circumstances that the application is not pressed
Well, in
today.
those circumstances, don't ever bring an application like that before me again.
Yes, Your Honour. The father does seek the alternative to the recovery
Don't
order
you laugh.
application, Your Honour, is that he would have liberty to apply on short notice in the event the mother failed to return the child to his care.
Oh,
in the
there's
event
no
that was
orders.
made.
Look, you know, I think too many application recovery orders are made without thinking about the effect on the child. The effect on the child of removing, sometimes without notice, a child, 2-year-old. Okay, my experience suggests sometimes this goes very, very badly. I think I would never be making orders for recovery in these circumstances. Thank you anyway.
Your Honour, there's one more
Anything else?
matter that I wish to be heard on. It's the
Yeah.
application in the mother's case for indemnity costs. In
Yeah,
my
that's
submission,
right.
it's
I'll
a,
deal with it now.
thank you, Your Honour.
I mean, costs have to be dealt with in the context of multiple things, including behaviour, capacity to pay, offers, and you have to get over 1171 first. That's why we wouldn't. So preserve your rubber for that one for another day.
Your Honour, the only other issue raised in the mother's material as opposed to the father's is that she seeks an interim order for sole parental responsibility. There are no urgent, pressing, major long-term
Well, the
decisions.
act
for
doesn't
Stewie to
require
be
you
made.
to make.
No, Your Honour, my submission.
Indeed, what major decision do you see on the horizon that someone has to make?
Your Honour, that's my very submission. There is no such horizon or
That's the
decision.
case
taken on
going forward, Ms. Horsley.
Thank you, Your Honour. None further submissions.
Yes.
And let me keep that door open, Your Honour.
Yes.
I don't press.
You.
Thank you, Your Honour. I don't press the application for sole parental responsibility. There's no evidence before you that any decision of a long-term nature needs to be immediately made. Your Honour, we have a 2-year-old. Let's not lose sight of the fact that this little child's reality at 2, just over 2 years old, that he's lived with mum and dad, of course, when together, but dad was absent 5 days a week working. Commendable, no criticism made, but this is about little Stewie's reality. Father's away 9 to 4. We know that Stewie got up at 7, and you would understand your own child at this age isn't staying up late, terribly late at night. What we also know about Stewie at 2 is that my client's at home. She's been unemployed, and sure, she spent 5 nights at Belmont with some mental health difficulties. But the father didn't look after Stewie on his own. His own mother, Thelma, was there, and you'll find that at paragraph 41 of my client's affidavit. So the task,
I object. That's disputed evidence. That's not common.
Thanks, thank you, Your
don't,
Honour. I reserve the right to interrupt. I expect counsel as inevitably, I can tell you, as a guide, Ms. Brasch and Ms. Horsley, here we are. And litigants in person have to sometimes be reminded that keep going.
thank you. So let me talk about the pathway in my submission, Your Honour, that's appropriate for this little 2-year-old, a meaningful relationship that is safe. I take Your Honour to the decision of DEITA, DEITA and DEITA of 2011, which says you cannot discount an allegation simply because it's in dispute, and that's at paragraph 18.
Well, I know the law, thanks for that. I appreciate that, but can I tell you, the area in your client's case, which most concerns me, is that only 12 months ago, she had 5 days in it. Well, I've got not one skerrick of evidence. She's a respondent. She's moved away from the doctor she most likely had where she was living at Castle. I don't have a skerrick of information about her therapeutic involvement. I have nothing. And unlike some of the other allegations, which are he says, she says, this is clear evidence of a forensic issue, which is concerning, not at the diagnosis, but that it reached the level of her involvement, that she felt a need, voluntarily, I understand, that's her evidence, to take 5 days of treatment.
And to her credit, Your Honour, and to her credit, rather than struggling, as she says in her material, with the state of the relationship she found her in, as she would say, aggrieved with family violence.
Yeah.
To her credit, one, she tells the court, yes, I did think about it. It was a cry for help of a suicide, sleeping pills, and alerted Peter. So there's a cry for help. And to her credit, voluntarily admits herself for 5 days.
And to her credit, that was 12 months ago.
To her credit, that was. But let's look at the father in my submission. The father's response to her mental
I'll let you talk about the father at the moment. But what I'm saying is, are you asking me the limited information I've got, that I should draw some comfort from the fact that the mother has been stable for the last 12 months against all these pressures, all these terrible, unhelpful things going on in the family, the breakdown of the relationship, that there's no other evidence of any other trigger in the last 12 months?
That's right.
Okay. Right. Well, before you go to the father, you want to tell me something about?
Well, his reaction is, no, I was going to turn around. What does the father do with response to my client's mental health? That which he seemed to elevate to a risk now, an unacceptable risk, part of why Stuart has to live with him. He now tells the court in his affidavit that he can, when Stuart lives with him, he can work flexible hours. We, of course, have nothing from his employer about that.
No.
But he also tells the court that my client's mental health was deteriorating in paragraph 12. Paragraph 9, he refers to my client's suicide threat.
Don't worry about that.
No,
because,
but what does he do, Your Honour?
well, I'll tell you what he does. He goes to work every day and
Thank
leaves
you.
the child with the mother.
Thank you, Your Honour. My point
So
is
the context for me is, if he's so concerned about his child and the care of the mother after these events, how can he sensibly, contextually, go to work every day? Leave that little child who was at that stage just a baby in the care of this maniac.
That's
The
right.
difficulty is, it doesn't make sense. However, other things don't make sense. Her allegation about sexual abuse, really? Is that the best you've got? Because have we reached a level that when a father, in this case, bathes a little boy, and I don't know how you can bathe them without them being naked, that we have to assume without any other context that something untoward is going on. Can you help me there? Because I'll tell you what worries me for this reason. One, it's so vague, as Horsley says, it troubles me. Secondly, there's no context as to when this occurred during the course of the last 2 years of the child's life. Thirdly, Mr. Perry says there's been a disclosure made. I have no context of that, no evidence of that. The client who's responded just recently with her affidavit mentions nothing. I'm concerned that this might be an overreaction and likely to affect the way that she's supporting the father's relationship with the child at this very early stage. Can you help with that?
I certainly I can, Your Honour. The highest it goes in terms of risk of impropriety is paragraph 20, 13th of September. I found what Peter was doing to be inappropriate because he was touching Stuart's property parts. That's, as I said, Your Honour, the highest.
Well,
I can
yeah,
take
that's
the
not very high. What does it mean?
Your Honour, I'm not asking you to make a finding today that the father is an unacceptable risk with respect to
Well, then
sexual issues.
What is the basis for supervision?
The family violence that my client says has been committed upon her and in the presence of Stuart.
How old was he?
Which one?
Stuart. How old was he?
He's 2 now. My client says it went throughout the relationship. Therefore, Stewie, the risk to Stewie is being in a household where there has been harassing, throwing, gaslighting. That's the risk in my submission.
And I appreciate there's no corroboration for any of this, even from her mother or parents. I don't know if they were there visiting. But it's early days, accept that.
Your Honour, that's the nature of family violence. It's often behind closed doors.
I also understand that on the basis that you're not pressing the sexual abuse issue, you raise this other issue. Can you help me with anything in your material that tells me when the supervised time will commence?
Yes, fortunately, Your Honour, Gympie is able to give time commencing.
Is there anything in your affidavit about?
No, Your Honour. But you can ask the question.
Well, I know, but see, if you're going to make an application for supervised time, you need to tell the court when it can happen. Because my experience is that you can't always just walk in and say, can you look after supervision? Maybe other people have a different experience. We're not Spain where it takes them 5 years. What I want to know is why? Because the effect of your client's application is that your client would not, as a result, what I'm seeing, there'd be no opportunity for relationship between this child and the father 7 weeks without time out and for who knows how.
Well, Your Honour has asked, and I can indicate to you, I have instructions that Gympie is available to commence this weekend. For not less than 2 hours per fortnight is the application.
Well, what's and the intake?
They can start this weekend.
Yeah. But that's why I put that on evidence before me because that's not what I'm hearing every day. I'm seeing this busy with every day. People are telling me Gympie can't take anybody.
Your Honour, they're very advanced in Gympie.
I see. And I mean, and the fact that Mr. Trump has all his sort of practice in Gympie tells me a lot of things. What I'm saying to you though is that if you're going to make an application for supervised time, I need to know because at the moment, and the other concern is what has your client done to in any way promote some time between the child and the father since she unilaterally agreed to unilateral relocation? To give those to the father?
I'm not going to give evidence from the bar table.
There's no evidence. There's no evidence that your client told the father she was going, is there?
There is no evidence.
Thank you. So, what has she done since she went to try and promote, even sometime? Can you do anything?
I think somewhere if I'm not confused with the matter I did yesterday, which sounds very similar to this one, Your Honour, I think there's been some phone calls, some FaceTime.
Phone calls for a 2-year-old?
It hasn't gone very well because of course school doesn't.
Of course it hasn't gone well. Phone calls are not a paddle. Phone calls are not kicking a ball. He's walking. He'd probably like to run around.
Your Honour, my client's position is safe, which is consistent with the meaningful relationship that Your Honour is going to try and do your best to craft, but one that was safe. My client's position is not.
Now, can you tell me about the other case management proposals? Because we unfortunately are against the time.
All right, let me quickly say then, Your Honour, Stuart, the father's proposal is completely unchild focused, will rip the 2-year-old off his primary carer.
Yeah.
The alternative proposals, lovely, it was a proposal on the affidavit material. It is not in the actual application.
My proposal.
For the father.
My proposal.
There is no money. It would be lovely.
For what?
For my client, other than the $100 a week that the father pays the mother and children, that's all my client has. So as marvellous as it might be, but heavens, the bird nesting really, or the in and out thing on the Jeep really, Your Honour, would have to be circumspect about that when the father accuses the mother of being a crazy and my client says he's unsafe. Sharing a house is a recipe for a disaster.
What about sharing a house? Tell me this, is your client's objection to returning, but he what you're saying on your instructions, that she wants to have the security of being able to remain in the home and not have to worry because her capacity, her income is no different in the house than it is to Gympie, is it?
Well, she's living with her parents who are able to provide for her. You're not providing for her.
There's no evidence they wouldn't provide for her. We're talking about house.
No, I'm talking about food in the fridge, Your Honour.
Yeah, but she's got money.
$100 a week.
And the father, I'm putting it to you, is it your position? Is it your position that if, for example, the father, I don't know if they even had a child support assessment, they've only been separated 6 weeks.
The child support agency doesn't work as quick as this court.
Well, then we might need to be creative. Maybe they can do something. Because what I'm concerned about is it seems pretty clear to me from having your submissions, that that's where the child should be. That's where the child should be. And that, in my view, having heard those submissions, the child should be there with his mum. That's the child's optimal outcome on an interim basis. And what we need to do is look at some alternatives that help secure that for a time being. And as I understand from your client, I appreciate she does have a car. She hasn't been able to come down here today. How did she get around? Did you got a licence?
Yes, she does. She, her parents.
So she needs a car. She needs a fact that at least for the interim, someone pays the mortgage. She gets child support. Right. Well, why wouldn't I think that these parents would try to create the optimal outcome for this child? That seems to me to be the optimal outcome.
Perhaps, Your Honour, that's something, now that we've had your indication, Ms Horsley and I could go outside and have some meaningful discussions.
I think you should.
My client would welcome that opportunity.
Yeah, I think you take me through. I appreciate that you've got a really considered submission on the family report. I don't want to rob you of the opportunity to tell me about why you should have these people. So go ahead.
Trump lied, Biden too nice, so strike them off the list. Hillary Clinton, she has been around a long time. She ran president of the Australian Social Workers Association, is well credentialed. But to come up with a second and a third, Your Honour, there's a new person on the block. His name's called Mayor Pete. And I'm told the kids love him because he's young and he's vibrant and he calls himself Mayor Pete. And he's got shirts. He's got Mayor Pete shirts and the kids love them. But you'll be impressed because it says respect, belonging, truth, teamwork, Mayor Pete 2020.
Looks a bit small for a social worker.
That was the one he gave me. The other one then is the bloke who hasn't been around for a long time, a report writer who was very popular in about 2007, might have been caught at a nightclub at one point sleeping in New York, but he's back on the scene, he's got a bit of time to do. So the next person on our list is... So they're the three report writers we've replaced.
Clearly, you seek an order under 62G, but that's not a practice or price report.
I don't think that's right, Your Honour. It ought properly under, it ought properly,
Well,
I
it's
think,
got to be
report under
a court expert or a
that's
civil
right,
expert.
Rule 15.
And so then, apart from the fact that the father is working money, I accept that. We don't know the cost of the report. Why do I need it now? Why wouldn't I put this proposition to you? Why wouldn't I leave the determination of the filing report until we've got we settle this matter down, we get them into status, we get little boy back at mother done, we get some time going appropriately, and we get some of this forensic information about mum's health.
My client's just Instagram me, she's fine with that.
Yeah, good. Well, there you go. No judgment required. All right. Now, those of you who I've had the privilege of having before me may not see a lot of difference between what we just did. And when I was asked to do this months ago, it seemed like a good idea. I'm not sure. But when I texted Jacoba recently, said, "What do you want to do?" She said, "Just be yourself." So true to form, I've been myself. When I approach these matters, which I approach here, if I wasn't giving judgment, I would be sitting them outside of the client. Now I understand that I'm being, I would be in a sense asked to make a coercive order if I was forcing Samson Habit number 10, Evanston authorities that say only rare circumstances. So I try and find a way around that. Because I get back to the simple basic premise. When I read this material, they struck me as good parents. And I'd start my judgment with saying, these parties, up until 6 weeks ago, were in a relationship that ended then, there had been some tensions. They had dealt with what must have been a very confronting inter-family situation where the mother had to have hospitalisation. Very difficult. And yet they seem to have got over that. And it's both of them. The father didn't opportunistically say, "Oh, well, you know, here we go, this is the end." No, they've had 12 months. So the importance of the chronology and the context is, I don't minimise the fact that in the relationship there has been some aggression like that, and I would want to think about how I would try and ensure that he's stable before he I wouldn't, this is not a case where with the history of care that I would be comfortable placing the child in the care of the father who's working full time, who hasn't given me the details of the support he's got. And my experience is quite often, they'll say one thing now, and then there's nothing, as Jacoba says, nothing from the employer or that. However, what I want is enough time and frequency to monitor what's going on as we get through the next stage. There'll be some other stages. What happens to the house? I don't think about the mortgage. I don't know how to do it. They were paying it. Now, there's no suggestion in any of the material that part of their fight was that they were going broke. Right? There's nothing there. And so, in a sense, you're sometimes looking for things you're not told rather than things you are told. I would feel comfortable in allowing Dad to have time. I would encourage him to, in his great flexibility, to say to his employer, you know, can I get a whole day with the son? I mean, I have a personal view that for a lot of reasons, children in daycare really early these days. And they have to, because both mum and dad are working and they want socialisation. We heard all that, haven't we, Jeff?
Yeah.
But there's nothing like kids at the school, you lose all the opportunity to spend that really valuable time with mums and dads. I want to explore that. So well, maybe if you're so flexible, you can work a Saturday morning where you don't have the child or something, your safety expert, whatever that means, and you can spend some time if you want. Because the ultimate result for this company is, I think, on the material, a likely inclusive care arrangement. Not necessarily weak about, because we don't start there. We have to consider it when we deal with the parental responsibility, of course. But I also think we need to consider about his daycare. No, I've got nothing for the daycare. He want to be playing us every time he's in there. But no one's saying we took him to daycare. We used to scream when we dropped him off. But I hear that occasionally, you know, separation anxiety. None of that here. Little boy goes off to daycare, loves it, spends 3 days a week there. Grandparents are important support for parents who are going to live. These are not young parents, 34 and 32. You have cases, I have cases where you've got young mums who've got 3 kids by 3 different fathers and they're only 26. They've got no money. They're tough. And you look at the eyes of these often mums and you see a life that has just been overtaken by being a parent, all their hopes and dreams. It's really tough. In the end result, your focus has to be on this child, and at this stage, stability. Now, and not getting too far ahead of yourself. Well, look, eventually, mum might be able to relocate again, and eventually this might happen. No. Settle it down now. I wouldn't be ordering a bad report anytime soon. I'd be making some orders for more data. I don't know if I'd want an ICL straight away. I mean, the reason fact is some of them are there. I am obviously concerned that unsupervised time with the father could involve further allegations being made. The father's not able to do it at the same time. The allegations made thus far it wouldn't concern me that he hasn't unsupervised. Well, those are.
Can I just interrupt there just for a second, Judge? If the allegations were more precise, more serious, more substantial, Dad's case, if I was running it, would also have been included. If Your Honour's against us and wanting to put in place a supervised time arrangement, potentially an affidavit from Grandma talking about her availability and willingness to act as a supervisor, just to maximise that time away from the contact centre.
Look, the issue you think about when you've got early allegations, I mean, it's all about context. You look at the authorities, it talks about context, opportunity, context. Children, very young children, don't have a great appreciation of location. And just because they say something doesn't make sense doesn't mean that something didn't happen. And of course, courts are loath, and some people are loath to make definitive, it did happen, it didn't happen. But I can tell you one thing, I mean, since I've become a family court judge, I've been trialling in Brisbane what I call discrete sexual abuse. And when I look at the Magellan cases that come to me as a Magellan, some of which have got horrendous allegations of abuse, I have picked up in the last 12 months 5 or 6 cases where I say, I think I'm going to have a discrete hearing on sexual abuse. And they have some indicators, I won't tell you what they are, that would be telling you too much. But what they involve are generally, as there are in these cases, no physical evidence. No one's coming in and saying, I saw him or her do it, right? So you're in this uncertainty. But then you see lots of context that you've got to consider. And if I think it's a case, and then you get a family report from Jeff and says, well, if the court finds that, let's say, it's not always the father, often the father, the allegations, if the father has sexually abused the child, I'll tell you what, that's a pretty easy pathway from there. But if, and then you'll say, but if the court doesn't find that, then you might consider this. And my concern has been with these cases, get them on quickly, because especially in Sydney, I was getting these cases here in Sydney where allegations were made 2 years earlier. The father, often but not always, had no time or supervised time, often no time, 2 years. You get to trial and sometimes the allegation is no longer pressed. You have that experience. They've got good counsel, but not enough evidence. You don't convince, you don't have the evidence. I know you've got the belief, you don't have the evidence. The belief's another issue, that's what both of you know. So then you can say, oh, but Your Honour, father hasn't seen the child for 2 years. So you want to make an order about long-term care, don't make interim orders because they've been in the system for 4 years waiting to get a judge. So my protocol, I've got about 5 years or so left before they put me out the pasture, is I'm going to keep looking. I'm going to keep looking for cases of sexual abuse that I think are amenable to discrete hearings. And the four courts recently looked at the decision, they looked at the discrete hearing in a similar situation, not from me, but from Judge Jarrett. Approved it, but not for every case.
I was in that one. That was a domestic violence, significant factual findings were made.
And I think family violence can be a little bit more difficult to do with because there are lots of strains to that effect on people. But we need to keep looking because I can tell you now, in a case that's settled out today, I did a discrete hearing, didn't find sexual abuse, the father's taking out supervised time, was on for trial, the day was all happened within 12 months, so I'm getting pushing it through it. And in respect to the parenting issue, the parties agreed today on a form of order whereby the father's having substantial significant. And they didn't have a trial today because sensible counsel before me helped their clients find that solution. Now that's going to be a better result for everybody. However, the resources are limited. So I always say to people, you've got to run sexual abuse allegations. You need to really be clear that it doesn't come back and bite you. Right? And that's not to say, and the court would never be heard to say, ignore what the child says. But if the child went to the mother or father and said the Martians have arrived in the paddock at school, you'd say, don't talk. But of course, in a low trust, high conflict environment where a parent, mother or father, wants to think the worst of the other parent, they very easily will grab on something. And it's hard, it's really hard. And you've got to find that balance. I didn't think this was a tough case to the extent that I think the solution was obvious when I read it, and I just had to get the people to that position. And so you say, well, that's not your role. You shouldn't be intimidating people into telling them what to do. My answer to that is don't put an application in my court. Because I'm responsible for that decision. And I know the limits of my powers, and I know where I can't go. People have said, oh, they'll make you accuse yourself. You know, you're a bit robust. And you've got to be careful. But at the same time, if you start from a position that I started when I read this, I thought to myself, these are, actually quite good parents. They've got a few issues. How can we get them to be good parents together? Because that's the best result for this little boy. And I can play a part in him getting to that position. And sometimes, you're pushing the car up a very steep hill. Got lawyers, silks, really consent person, but you keep doing it because every parenting case a judge does, there will be cases where you'll think the parents don't deserve all your efforts. It really pains, that they're not nice people, and they're doing it really difficult. They're really difficult. They made lots of things that they shouldn't do. They shouldn't say that. Shouldn't do that. Shouldn't put that on Facebook. Shouldn't start doing this at school. Lots of stuff, you know. But every parenting decision as a child, you should never lose focus. If you don't lose focus, then you can't do that because you're advocates. So when you come to a judge like me, you've got to remember that I won't be persuaded by the best of arguments if they don't seem to have a hint of what's in the best of the child. However, the mark is not always easy.
Can I add on to that? Yes, we're advocates. But first and foremost, we're officers of the court. First and foremost, we're officers of the court where the best interests of the children are paramount. Our second duty is to our clients, but don't lose sight of that. And that, gets back to my let's write nasty letters or let's look at problem solving.
Yeah, and look, it's not easy. I mean, I think you as practitioners in family law and by WhatsApp to other places at the bar, you have chosen to practice in an area which is not easy. You've got to learn to be able to leave your work at home. That work at home. I mean, I remember a few years ago, because I read everything for the next day, and I offered it in bed, and I'd be saying, "Oh, look what this said," and my wife would say, "Stop bringing files into the bedroom." I said, "Well, I want to be here with you, but I just got to read this file." I'm not a very good example. But I've had the benefit of many years of very sensitive advocacy from people in Queensland who care about the work they do. The whole purpose of the day was to understand that we're all part of the solution for this. We talk about parenting, you can apply similar things to other areas of the course of jurisdiction. Some are less, tugging on your parts. And that's some of the property stuff's really tough. You see people whose whole lives have just resolved to not much stuff you feel for. But I encourage you to continue to get better. The whole purpose of today was to see, hopefully, with a little bit of clarity, how what you do is important to what I do. You know, judges are not important people. Judges have an important job. And the importance of our job runs from the fact that we have a duty given us by the Parliament to make decisions that affect people's lives. We need your best to help us deliver our best. And when you don't, well, then it should be a problem. Yes, Deborah.
I was just going to ask from a different perspective. If we're officers of the court and we're working and we understand the direction that our judicial is going in, and we see the benefit of that approach, but we can't get those instructions from our client. What happened, for instance, if in that case, Jacoba's client said, "I'm not going back to Brisbane, I'm scared."
And I would have said to her, you careful what you wish for, sweetie, etc., but then you've got to put your instructions.
Can I say that I'm sure I don't forget what it was like, acting for people.
Greg Richards is still haunting.
The day when I practiced on the Gold Coast, you used to bring them up in the car with you, and then you bring them back in the car with you. There wasn't a train, so it was a nightmare. What you do is you do your job. You make a decision, and I probably would have made a decision that if the mother returns to the home, right? If the mother returns to the home, then child is removed. Because I saw the actions of the mother on the evidence before me as not well considered. And you can't be worried about, rush off the appeal court. Look, of course you do. I don't make decisions worried about the appeal court. I've been doing it so long now. I just worry about making the best decision. And if I'm wrong, well, then someone else will tell me, I guess. But there's lots of cases that I've had where I guess people could have appealed maybe successfully, and not many that have appealed unsuccessfully that have appealed. So I guess again, because what you don't know what I never know is, having made that decision, and if I've got these cases wrong, if I've got these people wrong in my heart, in my mind, when I read this stuff, then I guess I'm going to hear about it. So, for example, again, as case manager, I wouldn't let this sit in the list for 12 months. There's more information I need here. I want to consider ordering a family report. I might consider getting a psychiatrist. So I would keep it under my wing a little. That's what I would do. I still do the family. No, I shouldn't. But I'm do it anyway. Because I don't want this to blow up. You know? So I would go with my judgment, and I would, as I said before, often wrong but never in doubt. You've got to be certain about what you're doing, and you make the decision, and you bring it back. And then look, if you made a wrong decision, you correct it later. You're not infallible. I think that was for the benefit of this child. House going to be sold probably, and all this stuff. So yeah, you get those, everyone, and of course you get the hardest ones where, and this case is another example of the real conflict between 60cc to A and B. That's really where the tough ones are. In banks, when you look at banks, it's just concentrate the things that make a difference. You can't do with all the settings. But I can tell you, in my experience, with good counsel and good lawyers, I have lots of sisters who have been before me. I haven't had too many people when I've given them an answer have come back and tried to resist it totally. So you must be doing good work out there. I know what you tell them. You're probably saying
You
things
should
like,
see what happens if you disagree with him.
say, he's bad, we can do something, we can do this, we can do that, blah, blah, blah. I don't know what you're saying. I don't know what you're saying. I haven't made, you heard me say, I haven't made the decision. I gave it the proposal. I put a bit of pressure on. But I need people to move from their positions into the centre of what's in the best interest of the child. And I don't have any compunction about using whatever skill I've got to try and get them to focus. And the ones that are always going to go to trial, the ones where they are so far apart, I want to fast track those, make the findings and say, sadly, you're not going to have any time at all. One of those cases, and not to keep flogging that dead horse, but it's not going to happen. That's not happening either. So it's about, that's why I come back to the adage about good case management. Generally can not always lead to good results, but bad case management. And that's a very important part of what you do in an interim and post the interim. Don't lose sight of that. Now, we've got about another 5 or 10 minutes. If there's any other questions out there, want to be very quiet.
Can I just add something in response to Deb's question?
Yeah.
If you're dealing with a client who says, I've heard all of that, I still want you to run my case in terms of my primary proposal. If there are things that your client would want to secure, even if the judge is against her on her primary proposal to come back, get those instructions as well. Because if you're not putting the submission, which is, if your honour's against me in relation to that, my client says, if you were doing this, despite her primary position being something different, then she would also be seeking orders which would potentially meet some of her interests in that respect, whether it's an order that the father be restrained from attending the property without, permission of the mother, whether it's an order that, the father be responsible for the mortgage so as not to put her under any stress or pressure or whatever it might be. If you're not putting those proposals forward, you're not even giving the judge the opportunity to consider making those types of things. So I'm a big fan of, if your honour's against me, then there's also these factors to consider. Some people feel like we can set clients' case by putting those propositions, but I do think that if you're agitating your primary position clearly, firmly, strongly, and you're still allowing your client's alternative to be heard, it's not putting it as a proposal, it's not accepting the judge's outcome, but it is saying there's also these other things to think about.
And look, you do have a duty to the court, you have a duty. The client says, I don't want you to agree to that. You've got to, if they don't agree, that's what you do. And what you're going to do is make the judge make the decision, but that's what we pay to do. It's not a problem with that.
They're the days where some of you don't know, like, come out of the dress colour.
But one of the, testing Steve, one of the most difficult cases for judges is relocation. Now, when you've got cases where you've got identified risk, you can hang your hat on something, forensically, there's certain pathways of both. But, relocation cases almost always involve good parents in an intact relationship who want to legitimately get on with their life. New partner want to return to where their family are, where they've got family support, where their friends, where they've got a job. Overseas makes it even a bit tougher. I've got a case coming up, which is a relocation case. He said, Dad wants to take the child to Singapore, Mum wants to take the child to Vietnam. So it's not really a relocation case, it's really a disputed residence case. But on an interim basis, if you're acting for someone who wants to bring someone back, often but not always the mum, or stop them from going, you've got to make it clear how you're going to, in an interim basis, support them remaining. I constantly see people who say, she can't go because of my relationship. But I want to stay in the house. And I could have told this guy to say, offer her in the house, was thinking, pretty obvious, all these practical issues actually impact. And also, in some judges like me, I've got a lot of stake not changing schools, not changing childcare, because that's the children's century. There's chaos. They need to be able to go somewhere where they feel safe and loved and supported, and they've got their mates, And so, on an interim basis, I get really twitchy when I'm asked to do something which is going to have a significant change in their environment without better evidence. That would be very much easier. So think about, when you're preparing this case to do submissions, think about the weaknesses in your case, because they'll be the strengths of the other. Deal with them. So if I want Mum to come back in this case, how can I make it look reasonable rather than making an application that I've never had a child in my private care, it's a child with me. For all the reasons that were said by Jacoba, that would say, well, what are you thinking with? Right, any other questions? Got about that?
Also, any questions on the webinar also?
Webinar, they can't hear us. Nothing else? All bets gone. I know I'm keeping you from drinks. Yes.
Should this application have been made?
Can you just repeat it?
Yeah, so for the webinar people, the question was, should the application have been brought in the FCC? Speaking as Dad representative, absolutely. There's nothing on his case that would support under the protocol for the division of work that he would file in the family court. The other thing about what Dad did in his material, some of the procedural stuff that you no doubt picked up on when you were reading through, his notice of risk is a call. He doesn't identify any of the material. That notice goes to the Department of Child Safety.
Well, not all of them. Not all of them.
Incorrect.
No, that's okay, because if we said all of them, then they're automatically audited. There's a filter. But you remember there's a filter for the Parliament, and the President of the Law Council of Australia, who's here, we should be very, very proud of it. Another Queenslander being here in the Law Council. Well done. Education goes through, then a witness is instructed. The pathway will become a little more difficult. The appeal division. Division 1 judges, which are family court judges, there. Division 2. How the work's going to flow tonight. I'll tell you what, whoever works it out, you probably won't be needed for. It's got to have a focus on giving people, empowering people to get out of the court system. We can't have people in the system so long that can't get it resolved or they can't move on. And it's not an easy thing. We've got lots of new registrars now. They've got to play a very vital role in things called the Evidence List, White House projects, and things like that. Really exciting stuff. Lots of triaging. Lisa O'Neill, of course, been doing enormously good work, changed screening. There's been legislation to protect confidentiality. There's been a lot of stuff done, all directed to protecting family violence issues and things like that. So you're at a very exciting time of your careers. But you know, when you're sitting with that client in your office, it's not that exciting at times. You're just trying to get a good result for you. Work hard, prepare hard, learn from your mistakes. I try to learn from mine. And I am very proud to call myself a family lawyer. Still regard myself as a family lawyer. I think it's an area of practice that adds real value to our society in Australia. I congratulate you on choosing to continue to pursue it. And thank you for your attendance.
Rebecca, Jacoba, and Jeff very much for their presentations. Very insightful. Justice Baumann is inclined to take a gift, so he's going to nominate.
I'm sure it's a breach of some act. Perhaps I'm sure it's a breach of some act. There's a card. That probably doesn't breach that.
Just the $500,000.
But there was a gift for me, wasn't there?
Yes, it's over here.
And I am going
Two
to.
parts.
There's two. I've got two lists of attendees. Because ever since I've been doing this sort of stuff, for years, festival side, all that sort of stuff, I always like to have a talking to. So I always get lists. So if you're here, sorry for the people in red pens, I'm not on this. So I am just going to randomly pick one from page one list and page two list, and we get what was for me. There's two, and I want to sort of be a snake or something.
Yeah.
Two? Right, so I'm not even going to work out. This is sort of like, huh? Okay, but this is like that thing that have with the donkeys at kids' park.
This is for the champagne.
Sorry?
Red line.
Oh, jeez. Now, so, Rebecca Finlayson, is she here? Put your hand up, Rebecca. For those in the second list, you're not in the front end of the plane. We're in the second list, which is from J's to Y's. Nicole Miller. Nicole here? Can I say one last thing? It's not lost on anybody. Our Grand Australia, that's been a very tragic time of recent months in family. I thought that the way in which the profession has come together, both within court, staff, profession, bar, has been a reflection of the sort of people attracted to family. It was very powerful. I don't want you to think that people in the court system, the judges, people in staff weren't feeling very supportive. And I hope Judge Andrews like similarly. And as we move forward, it's a reminder of how tough a job we do is. And it's a good thing to remember that, because if we thought it was easy, some of us wouldn't do it, and we might put the effort we need to get it right. So I wanted to thank all of you. Many of you play a role in supporting others, maybe in people who know you guys very well. And I want to thank you. I thought it was a very powerful thing and a very tragic situation. And I hope all of us have a pleasant Christmas and come back in 2021 with a new president of the Royal Council.
I think I'm the second ever, second family lawyer.
Yeah, I think John Folks was president back
So, good year for us all next year, family.
So have a loving, safe Christmas with your families, and we look forward to seeing you next year.